Yay, unlike yesterday, the intro video played fully. I like that. Things work. Happy Tuesday. Welcome to the Courtroom Files Live. We will start our morning with Judge Glazer, Miami-Dade. Let's see what's going on.
Okay, next case, there's somebody here. Was it corrections? Who had somebody out of turn? I'm calling up. We have Raul Rodriguez for an officer. I believe Officer Gene Gillis is here. And then I'm going to call the out of turns.
Mr. Rodriguez is present.
Oh, he's not here. Yeah, this is Mr. Raul Rodriguez. Good morning, sir.
Good morning, ma'am.
Sir, you were arrested for burglary to an unoccupied structure and petty theft. That's from October 1st. Second case, burglary and grand theft from September 19th. I will appoint the public defender's office for you. Officer Gene Gillis, are you there so I can promote you? Here you are. Give me a moment to review for probable cause.
Right, so it's package theft, should be dwellings, but it's curtilage.
Say it again.
It's package thefts, it should be dwellings, but it's
burglary to a dwelling. He's like the porch pirate, stealing packages on people's porches. Okay. There's video surveillance on F25-21823. You are ordered to stay away from the victim, Ivanova Augustine. No contact with that victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. Stay at least 500 feet away from the victim, their home, school, and place of employment, and stay away from their residence at 62 Northwest 48th Street in Miami, Florida. Count 1, burglary to the dwelling, unoccupied dwelling. What do you want on that? Is a signal 400, $7,500 bond. Count 2, petty theft. There's a value of $214, so it's a $500 bond. You gotta look at the other one 1 second.
Okay.
Officer Gene, you're here. Did you want to say anything?
Yes. Hi. Good morning, Your Honor.
Good morning. How can I help you, sir? You got to put on your video on mute and be sworn in.
Yes, ma'am.
While we're waiting, Mr. Rodriguez, for the other case, you're ordered to stay away from Patricia Hernandez, the alleged victim. No contact with that victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. Stay at least 500 feet away from the victim's home, school, and place of employment, including their residence at 557 Northwest 44th Avenue. Officer, raise your right hand to be sworn, please. Do you swear or affirm the testimony you're going to give in this proceeding will be the truth? If so, state I do.
I do.
Okay, thank you. What is your name and what is your police department?
My name is Officer Gene. I'm with the City of Miami Police Department.
Okay, how can I help you? Why are you here?
Okay, I was just wanted to emphasize that the Mr. Rodriguez is a convicted felony, and
No, it's a signal 400.
And
also, why did you charge it on the arrest affidavit? Not you. Somebody charged it as burglary to a structure. Shouldn't your officers write a dwelling if that's what it is?
That's correct, Your Honor.
So isn't that something you should take care of in your department and make sure they're charging it right?
Will do, Your Honor.
Anything else you would care to say, sir?
Otherwise, we are requesting a higher bond if possible.
Okay. All right. Thank you.
Judge, Mr. Rodriguez is currently homeless. He does not have funds for bond. Would you consider the TAP program?
Absolutely not. These are burglaries to a dwelling. I'm not giving him the TAP program, and I don't think he'd qualify, especially since the bond amounts are over $10,000. I'm sorry, do you have any questions for Officer Gene?
No questions.
Ms. Corey?
No, Judge.
Thank you. All right. So F25-21824, it's burglary to a dwelling. Let me just see something.
Right, the value's on the first line of page 2.
The value was $2,100. She's her clothing, with packages and items that were sent from Dubai. There's probable cause for the charge. In this case, the bond's going to be $15,000 bond count 1 for burglary to the dwelling, unoccupied dwelling. Count 2, grand theft is $5,000. Stay away from that victim's home. Thank you for coming in, officer. Good day, sir.
Thank you very much, Your Honor.
Right, next, calling Editor Jonathan Pullis. Why am I calling Editor? Detective's here, yes. Yeah,
Judge, who did you call next?
I'm calling a case editor on page 7.
Which name?
It is Jonathan Pullis.
Number 21. Is that for private or?
No, just because I feel like it.
Okay.
I picked one out of the stack and that's the one that popped up.
That works.
I guess people are observing and want it out.
Okay.
Your Honor, Mr. Fuller is a violent felony offender of special concern.
Okay, thank you. Good morning, Mr. Pullis. Sir, you were arrested for a case from October 5th. The charge is strong arm robbery, kidnapping, and 2 counts of battery. You're also out on felony bond. There's a hold for F-19 19900. And sir, can you afford to hire a private lawyer? Pardon me?
Yes, Judge.
Would you like me to reset this case to give you an opportunity to have a lawyer present in court with you?
No.
Okay. Do you own your home?
Yes.
Let me just, you want to waive the lawyer's presence for purposes of this hearing?
Yes.
Okay. Let me review for probable cause. Please don't talk about the facts of the case because anything you say can be used against you.
Yes, Your Honor.
Okay, I had a chance to review the arrest affidavit. Anything you want to say? I'm sorry, Miss F, how is this a kidnapping? You didn't,
So, right, it said that, 1 second.
I don't believe, it doesn't say he's trying to terrorize her.
Well,
He
I think he is. He
demanded
punched
her
her,
to go in the car and he,
right, punched her in the face, threatened to throw her phone in the lake, pushed
that was
her.
beforehand.
There's a struggle. It also talks about the victim. I believe she was hold on. It says she was later transported to the hospital for treatment based upon her injuries. Right, so he's pushing her face into the dashboard, holding her against her will. I think there's enough for the kidnapping. And it looks like this took place over a period of time.
All right, sir, you are ordered to stay away from the alleged victim, Veronica Morciego. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you have to go to her home for any of your personal belongings or no?
No, Your Honor.
Thank you.
They have
Thank
lived
you.
with me. Sorry.
That's fine. All right, so the state has filed a motion for pretrial detention pending final hearing pursuant to Florida statute 907.041. Just one other thing, I'm going to grant the state's motion for pretrial detention and find probable cause for the kidnapping. There's technically probable cause, but you're going to see the division judge tomorrow because that counts as no bond, and they'll set a final hearing on that motion. I'm just not sure if it's a strong arm robbery. He initially snatched the phone.
They're not snatched.
Don't talk about the facts, sir.
He said he punched her in the face.
That's after. That's
But
after
he did-
him
but
taking
he,
it. It looks like a sudden snatching, and then he used force on her, which is the battery. So count one is probable cause for robbery by sudden snatching. That bond is $2,500. Count two, the kidnapping is no bond. And count three is battery, that's $1,000. So you'll see the judge tomorrow. 2 counts of battery, count 4 will be $1. Because I guess there was a temporal break in time, is that what it is? Yeah. I'll set $1 for the battery count. Sir, does he have a public defender on his other case? Or he's a private lawyer? You able to run it for me if I'm heard?
Seth Levy.
Who is it?
Beth LeVay.
Oh, Levy.
I can't hear anything.
Seth LeVay.
Seth LeVay. Oh, he's a good lawyer. Give him a call and he'll be there tomorrow, okay?
Yes, Your Honor.
Have a good day.
Thank you, Your Honor. Today.
So, as always in Miami-Dade, they have a parade of allegedly beautiful, lovely, law-abiding citizens. Good morning, everybody. Happy Tuesday. Once again, welcome to the Courtroom Files Live. Barbara, thank you for gifting 5 memberships. I very much appreciate that. Let's stay in Florida, but let's go say good morning to Judge Mercer.
Yes, sir.
Mr. Holland, good morning. Mr. Holland, your mother is in the courtroom. You're here for one charge of failed to notify change of employment for a sex offender violation of sex offender statute. Mr. Holland, there is probable cause for that charge. Mr. Holland, I think you're entitled to a bond as far as I can tell. So I'm going to listen to the attorneys and I'm going to address your bond status. Mr. McDaniel.
Your Honor, I don't have anything additional.
I'm going to get your answer.
Mr. Mitchell.
Nothing at this time, Your Honor.
Mr. Holland, you wanted to say something, sir?
Yes, sir. I've been reporting it every 90 days. I report in for my register. And back in February, I had got a job at Wayne Farms. Now in they got that on file because I had to report it in. And so in June, I got laid off.
Hold on. John, you may want, he may be getting into the facts of the case, may want to be safe with that just in case.
I got confused with Wayne Farms because I don't think that's the name of the employer that he allegedly didn't report. So let me see who it was. Mr. Holland, the allegation against you was that you failed to report employment, but it wasn't Wayne Farms. It was Florida Department of Agriculture and Consumer Services. So this is something that supposedly happened in September. So this has nothing to do with Wayne Farms and earlier in the year. The allegation, what you're accused of is that you worked September 9th and 10th at the state of Florida at their agricultural law enforcement division, and that's the one you supposedly didn't report. Your mother has a question. Yes, ma'am.
The reason why he didn't get a chance to report that, because when he got laid off, he tried to find something to do, and he thought that that was sufficient until the boss man told him no, he couldn't work there. So it was like 2 or 3 days that, you know.
Yeah, what they're saying is that he has 48 hours to report in person or online employment or employment changes. And that's what he's accused of not doing within 48 hours. But he's entitled to a bond. I'm going to set you the normal bond I would set for this charge, which is $5,000 cash or surety. Now, cash or surety, Mr. Holland, means you don't have to come up with all of it. You can go through a bondsman. So let's say a bondsman chose to charge you 10%, which is kind of a norm. That would be $500 to get out of jail. You're not working right now, are you, Mr. Holland?
No, sir.
Okay. So that's the normal bond I've set for that charge. You post the bond, you'll be released immediately, ma'am. A bondsman will even negotiate that. Some bondsmen won't require the whole $500 to be paid up front. That's entirely between you and the bondsman. Let me see if your mother has any questions, Mr. Holland. Ma'am, do you have any questions? Mr. Holland, do you have any questions?
I love you, Mom. Get me up out of here, please.
Mr. If it's not like hang on a second, Mr. Holland. Mr. Mitchell, I'm concerned. It's an employment related. It's not like he was hiding and didn't report his residence. I'm considering a misdemeanor bond, which would be $2,500. What's the state's thoughts on that?
I have no objection to that.
Mr. McDaniel, what I'm going to do is I'm going to send him a $2,500 bond due to the nature of the charge. That means if you go to a bondsman, they charge you 10%, it'll only be $250 to get out of jail. But make sure you report whatever your requirements are, Mr. Holland. Make sure you follow those, okay?
All right.
Thank you. Have a good day. Thank you for coming, ma'am. We have Jordan Brooks next. Mr. Brooks, good morning. Mr. Brooks, you're here because you've been accused of one count of failure to appear in case 23-382 CT. The charges are attaching a license plate not assigned and failure to obey instructions from law enforcement or fire department official. Mr. Brooks, there is, well, actually, I can't find probable cause because there's no complaint. But what I can do is that it's a failure to appear warrant. And I was told this morning that you turned yourself in, Mr. Brooks. I'm going to appoint the public defender's officer representative. I was told that you came from Washington, D.C. to turn yourself in. So I appreciate that. And that changed your offer. Your offer was 30 days in jail. But when I was made aware of that, Mr. Mitchell has agreed to an offer of probation. So I don't know where we stand on that. You've got a bond already set. I'm going to ask that you listen to your appointed lawyer, and we'll see where we go from here. Mr. McDaniel?
Your Honor, I spoke to Mr. Brooks. He's going to plead no contest to the charges as listed. He'd be placed on probation for 6 months. He'd have a $400 fine. He does live in DC, so I explained to probation to go over with him how he can do the things that's required. I suggested to him that he pay that fine today before he leaves. I think he is going to try to get that fine paid the day before he leaves town. And he has waived his right to a jury trial and call witnesses.
Okay, Mr. Brooks, your girlfriend is in the courtroom and she wanted to say something, but now that the case, there's a plea agreement reached, I don't know if that has changed her mind. So ma'am, the agreement right now is 6 months probation on a misdemeanor charge. You wanted to say something earlier. Does that change your mind? Do you have anything you want to tell us?
They've already agreed. I was just gonna say the circumstances around what happened, but.
So if you're happy with that resolution and you feel like you can live with that, your girlfriend's fine with that too. Mr. Brooks, any questions about that plea agreement?
No, Your Honor.
Sir, is that the plea that you would like to enter?
Yes.
Mr. Brooks, I'm going to accept your plea of no contest to those two charges, attaching a tag not assigned, failure to obey instructions from a law enforcement officer, withhold adjudication of guilt, sentence you to 6 months probation on each case concurrent. That means a total of 6 months. They're running at the same time. $400 court costs and fines imposed in the attaching tag. I'm going to waive the court costs and fines in count 2. And you'll be allowed to do written monthly reports because you live more than an hour away. Mr. Brooks, that means every month you will either mail in or email in your report. And that constitutes reporting in person. If you don't send it in, that's just like you didn't report. So make sure, Mr. Brooks, you follow through with this and get this thing behind you. Lastly, Mr. Brooks, I let just about everybody get off probation early. To get off probation early, you've got to do half the probation. In your case, that's only 3 months. If you do the 3 months, you've stayed out of trouble, you got everything paid, there's an excellent chance you can get off probation early. So I would encourage you to try to do that. Mr. Brooks, what they're going to do next is the jail's going to let you use the phone if you need to. You may not need to. I'm going to ask your girlfriend that in just a second. But after you use the phone, they're going to get you dressed in your regular clothes. They're going to bring you to the courthouse because that's where the probation office is at. When you get here, Mr. Brooks, you'll meet with one of the probation officers. They'll go over the probation with you. They'll give you a chance to ask any questions about the probation, and then you'll be free to go. Mr. Brooks, let me ask your girlfriend, I'm assuming you've got transportation covered? Yeah. He will be here in 30 to 45 minutes downstairs. The county probation office is inside the county judge's office on the east side of the courthouse. Okay, your girlfriend's gonna be here to pick you up. Mr. Brooks, do you have any questions?
Will I have to return back for court?
No.
In
This case
person?
is over
No,
with.
okay.
There's no more court. The only way you would ever come back on this case is if you violated probation, which I don't, hope that's not gonna happen. No,
Yeah,
you
thank you, Your
complete
Honor.
probation, you will not come back for this case at all once you leave today because you live so far away. If you live less than an hour away, you have to report in person, but you live much more than an hour away. So you will report by email or mail, and the only way you come back to court is if you stop reporting or got a new charge somewhere while you're on
Yes, sir.
probation. Any
Thank
other
you, Your Honor.
questions? Wish you the
No, Your
best.
Honor.
Ma'am, do you have any questions?
I do have a small question. And
Okay.
I don't know who you're actually asking, but because of this, his license has been suspended, and we need to pay the fines, and I know this resolves everything. However, does that mean we can't do his license for another 2 months?
So the failure to appear got a license suspension, Dawn, because it's a traffic offense? Is that what happened?
Yes.
Okay, so what'll happen is we'll do what's called a D6 in error, and that means we'll clear that license suspension because now he's shown up in court and resolved the case. Now, I can't tell you, I don't know if he has to pay a reinstatement fee, but as far as the suspension itself, him turning himself in will resolve that.
And will we need documentation?
You'll get documentation from the probation office. The clerk's office will give you something when he goes down there. Yes, before he leaves today, he'll get some paperwork showing that suspension from Florida for this case is gone. It's been set aside. Okay. All right, wish you the best, sir. Thank you for coming, man.
Thank you, Your Honor.
Yes, sir. So there is one more gentleman that came in the courtroom. Let me see if he's here for a first appearance case. You here for a first appearance case, sir? Lori Hall. Okay. Lori Hall. And I'm gonna tell her who's here, sir. Your relationships, I can tell her. Miss Hall, your fiance is in the courtroom. Miss Hall, you're here because you have been charged with 25-350 CT. The charge is driving with no valid driver's license. This is a case where you've already entered a plea, Miss Hall. You entered a plea to 10 days in jail, but you were given time to pay a fine or come back to court and ask for an extension. When she didn't pay the fine and didn't show back up in court on her court date, that's when the warrant was issued. So Ms. Hall, I've already appointed the public defender's office to represent you. Probably if I haven't, I'm going to do that right now. I'm going to ask you to listen to Mr. McDaniel and we'll see where we go with this.
Your Honor, we just make a request to court to amend the disposition to include a purge of $400. She has 1 day jail credit on the 10-day sentence. And if she does pay that $400 at the clerk of court, she'll be released from the county jail and this case be resolved or served the remaining 10 days.
Mr. Mitchell, any objection to that?
No objection, Your Honor, and that is agreeable with the state.
So, sir, just so you understand the background, she was ordered to pay $400 within 60 days, or if she couldn't pay it, she could come back to court and ask for an extension. Tell us what's going on, ask for an extension. She did neither. She didn't pay it and she didn't come back to court. The warrant was issued. She has a 10-day jail sentence. Mr. McDaniel is asking that we add a purge on the sentence, which is the exact same amount she was ordered to pay months ago, and that amount is $400. Mr. Mitchell is not objecting to that. So what I'm going to do is I'm going to add a purge on this 10-day jail sentence. What that means is she pays the $400 or someone pays it for her, she's released and the case is over. Okay. If she's not able to pay it, she'll finish the 10-day jail sentence that's already been imposed. Okay. Ms. Hall, do you have any questions about that?
No, sir.
Her question is probably the same as mine if I was in her shoes, and that question is, are you going to be able to pay the $400, sir?
I'll try to.
Okay, so your fiance says he's going to try to get that paid, and if you can't pay it today, whenever you can get it paid, she'll be released. Now, sir, purges are made at the clerk's office when they're open. They're open 8 a.m. to 4:30 p.m. The reason I'm telling you that is if you try to pay it at 5 o'clock today, there's not going to be anybody there to accept it. So you have to come back tomorrow and pay it. So if you can get it paid before 4:30, she'll get out today. Otherwise, the earliest she'll get out is tomorrow. Okay. So your fiance is going to try to get that paid, Ms. Hall, okay?
Thank you.
Any questions, sir?
When I pay it,
When you pay at the clerk's office downstairs, they will give you a receipt. You take that receipt to the jail and you'll be released. They also will email the jail that it's been paid. And we're going to give you a sheet of paper showing the case number and everything. So if you can get that paid, she's going to be released and be done with this. Okay? Yes, sir. Wish you the best, Ms. Hall.
Thank you.
Back at the top of the list, we have Demetrius Richardson.
No.
You want to go?
I really don't want to go.
Got, come.
Mr. Richardson. Good morning. Mr. Richardson, you're here for first appearance accused of one count of battery. It's filed as a second or subsequent offense, Mr. Richardson, so you're accused of a felony charge. Sir, I've read the complaint. There is probable cause. The problem you have, Mr. Richardson, is that you're already on probation for battery on the same person. And according to the most recent stuff I'm seeing in the file, there's a condition of no contact with that alleged victim. Now, if that was modified, it's not reflected in the court file yet, but that's an issue you've got to deal with. So, Mr. Richardson, I'm going to set you a bond in the new case, but in all likelihood, you're going to be held for the violation of probation because of the circumstances. Let me see if the attorneys have any additional information before I make a final decision. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing at this time, Your Honor.
So, Mr. Richardson, the bond on the new battery charge, because it's a felony charge and because you're already on probation, is $10,000 cash or surety. Mr. Richardson, you've got a 7-day hold with no bond, and we'll see if they get a warrant or not within the 7 days. It would not come before me. It would likely go before the circuit judge, Judge Garcia. So I'll see you in 7 days. We'll see if they have a violation of probation warrant by then. If they don't, I will release that hold. You're free to post the bond here. The bond does have a condition of absolutely no contact with the alleged victim at all. Any questions, Mr. Richardson?
No.
All right. Wish you the best, sir. We have Jaques Daffin. I may be mispronouncing that.
Jaques.
Ms. Daffin, good morning. You're here because you've been accused of one count of aggravated battery. Ms. Daffin, there is probable cause in the complaint for this charge, ma'am. The good news is your criminal history is very good. You had something back 12 years ago, and that's it. That was all I see. Ms. Daffin, I think you're entitled to a bond. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Just a second, Your Honor. Let me make sure of something. No, Your Honor, nothing at this time.
Ms. Daffin, I'm going to set your bond at $2,500 cash or surety, ma'am. You have the right to go through a bondsman. You do have a condition of absolutely no contact with the alleged victim, ma'am. So if you, from this point forward, you can have no contact with that person that's accused you of this, but you have the right to post a bond and be released. And it's a cash or surety bond, Ms. Daffin. That means you can go through a bondsman. You don't have to come up with all $2,500. If you choose to go through a bondsman, you can. Ms. Daffin, we're also going to give you a court date for the felony court date, which will be November 6th. Corporal, I failed to put that on the record for Mr. Richardson also. Mr. Richardson and Ms. Daffin both have a court date for November 6th in front of Judge Garcia. If you'd give them those notices, I would appreciate it. Ms. Daffin, any questions, ma'am?
No, sir.
Wish you the best, ma'am.
Your Honor.
Mr. Holland has the same court date, November 6th.
I think it's the 4th. The 6th is a VOP date.
All right, I may have that wrong. Let's see. It is the 4th. You're right.
Sorry to correct you.
So on all those individuals, the court date for Mr. Richardson, Ms. Daffin, and Mr. Holland will be November 4th at 8:30, not November 6th. November 6th is a VOP date.
What was her bond again? I was typing something down.
2,500.
2,500 because her history was so good. Then we have, we see Mr. Booth.
Larry Booth.
Larry Booth. Mr. Booth, come on up. Mr. Booth, you're here in case number 24752 CT. You're accused of violent in terms of your county probation, Mr. Booth. Mr. Booth, I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Booth. He's going to admit that he violated his probation, understanding he's going to be sentenced to 30 days in the county jail. He had 5 days jail credit. He can be released from jail by paying the sum of $230, which is the remainder of the balance of the case.
Mr. Mitchell's had agreeable with the state.
It is, Your Honor.
So, Mr. Booth, this is typically how we handle cases that are where someone violates probation and it appears they had evidence to pay, but the only significant violation is financial in nature. We just typically only give a jail sentence and give them time to pay it and just be done with it. They'll be released. I know that you also didn't get your driver's license, but it's still the primary violation is your court costs and fines. You report it every month like you're supposed to. You just ran out of time, basically. So if you pay the $230, which is the same amount you originally ordered to pay, that's what you got left, you'll be released immediately. Mr. Booth, any questions about that agreement?
I'm saying if I don't pay it after the 30 days, will I still owe the 230?
There will be a civil judgment against you. Do you think you're not gonna be able to pay it within 30 days, Mr. Booth?
Well, I could pay it within 30 days, but can't pay it today to get out of jail.
Okay. I don't think anybody wants you to serve 30 days in jail. We want you to just be able to pay it. So the answer to your question is that what I'm gonna do is if you're still there in 1 week, I'm gonna ask the jail to bring you back up to first appearance. But I hope you're not there. I hope you've been able to come up with the $230 that you owe, and this all will be over with. So I hope that answers your question. Yes, if you don't get it paid, there will be a civil judgment for that amount.
Okay.
Okay, let me clarify that. So the civil judgment would only be for the court costs and fines, which would be $150. The rest of what the purge amount is your cost of supervision you did not get paid. But the civil judgment doesn't cover cost supervision. We don't put civil judgment for that. We only put civil judgment for court costs and fines. So knowing all of that, Mr. Booth, is that the admission you would like to enter, sir?
Yes. I would like to make a phone call, see if I can get somebody to come to 2:30.
Sure. You'll get to do that in just a few minutes. I'm going to accept your admission that you violated the terms and conditions of your probation, Mr. Booth. And in that case number, I'm going to revoke your probation 24-752 CD. I'm going to sentence you to 30 days in jail, but you can purge that sentence at any time before completing it by paying the remaining court cost, fines, and cost of supervision that you were not able to get paid on probation. That's $230. You will get to use the phone in just a few minutes, sir. Try to make that purge. Purge amounts are made at the clerk of court's office. Mr. Booth, the clerk's office is open 8 a.m. to 4:30 p.m. So if you do call friends or family, and if they're going to take care of it or help you out, make sure you tell them it needs to be paid by 4:30 p.m. or else they won't be able to pay it till tomorrow. So make sure that you know that. And if you're still here in 1 week, I'm going to ask the jail to put you back on the first appearance list. Hopefully you've been able to make that payment and I'll be over with. Mr. Booth, do you have any questions?
Yes, I'd like to know, is my sister Linda Richardson in the courtroom?
No, sir.
All right.
Now, some young lady came in with Mr. Holland's mother. She came back in, and I don't know who that was, but then they just left. That's not her. So we haven't seen her this morning. There is court in the other courtroom, so it's possible she's in the wrong courtroom, but she's certainly not down here, okay?
Okay.
Wish you the best, sir. We have Ronald Edinburgh next. Mr. Edinburgh, good morning. You're here for first appearance accused of 1 count of battery. Mr. Edinburgh, there is probable cause for the charge. I'm going to set you a bond in just a moment. But before we do that, we need to deal with your other PTI case. So Mr. McDaniel sent us that text this morning.
Yeah,
So
I didn't
don't-
realize that. No, see,
Just-
he just needs to be dismissed.
So let me tell you what happened, and then it's a really unusual disposition. So in Mr. Edinburgh, he had a PTI in 24-684. It was a really unusual one. It was one Mr. McDaniel was trying to preserve his lack of criminal history. So the agreement was a PTI with the only condition being served 10 days in jail. That's it. He did the 10 days in jail, so the case should have been dismissed. The problem is because of that type of PTI and there not being any supervision, the probation office isn't involved. So that normal step where they send a letter to the state attorney's office saying that the case he's completed his obligations, that letter was never sent because they weren't involved. The other problem is that court disposition says 1 year PTI. That was never, I don't know where that came from. It's not on the recording and we watched this morning. So Mr. Mitchell, it appears that he fulfilled his obligation and the state needs to dismiss the case. Y'all just weren't notified to do so like you normally would be.
Yeah, I'll dismiss it today.
No, I would have done a fine.
Civil judgment, probably.
Right, but I'm just saying, if you work it off the jail or if you
Hang on.
Yeah, and I have no idea if he worked it off or not. I had to find that out from the jail.
Yeah, there was a fine of
370.
370, yeah.
This was a 370 fine. So Mr. Edinburgh, we're just trying to get that cleared up. So you completed that PTI as far as we can tell here at the courthouse. And I'm gonna ask Mr. Mitchell to pull that case and go ahead and process the dismissal if that's what they're choosing to do, which I think that's what the agreement was. In the new case, the battery case, there is probable cause. I'm going to listen to the attorneys, and then I'm going to address your bond status in that new case. Mr. McDaniel.
Nothing, Your Honor.
Mr. Mitchell.
Nothing at this time, Your Honor.
Mr. Edinburgh, in the new battery case, I'm going to set your bond at $2,500 cash or surety, so you can go through a bondsman. And you do have the condition, no contact with the alleged victim, Mr. Edinburgh, so no contact with that person that's accused you of this. Mr. Edinburgh, do you have any questions?
No, no, sir.
All right, you'll get to use the phone shortly to try to post the bond, sir. I wish you the best. We have Joyce Stevens next. Ms. Stevens, good morning. Ms. Stevens, you're here. You were first appeared yesterday. I think you were not in the first appearance room. Mr. McDaniel, your attorney, asked that we go ahead and set you a bond. I set you a $100 cash bond. We thought your friends or family were going to post that for you, but I asked that you be brought back up to date if you were still there. So I'm appointing the public defender's office to represent you for first appearance purposes. I'm going to ask that you listen to Mr. McDaniel, and then we'll see what the state's position is. Mr. McDaniel?
Judge, it took me a while because, sheriff's office, no one gave me any kind of information about the family or anything involved in this case. So it took me all day yesterday to find the husband. I did find him and locate him, found the number. After extensive research, which I would really wish the sheriff's office could give me that information. I did talk to him, and he said he was going to come bond her out yesterday afternoon when I talked to him about 4 o'clock or so, 3 o'clock, somewhere in that neighborhood. Obviously, he did not. It took a lot more wrangling. The jail ended up finding a phone number for her daughter that's in Tampa, and the nurses did that, and they talked to her last night. It was after that I talked to him. It took him all day to find that number, and she's in Tampa, and she can't come down here right now. She was going to, contact her father to come bond him out and get her back home, but obviously he did not do that, and I'm not sure where we stand right now. I talked to the nurse who's trying to contact them some more. It's kind of, we are where we are.
Mr. Mitchell?
It's unfortunate, but I've got nothing at this time.
Did Miss Stevens come in with any financial resources with her, Mr. McDaniel? Do you know, or does Corporal Drown know the answer to that question?
No.
Did she bring wallet or money? I know she's retired. She gets
a driver's license, clothes, and her rings. That was it.
No, just rings, I guess.
Ms. Stevens, with your criminal history, you probably would be a conditional release candidate. I just got to make sure you've got somewhere to go, and that we kind of deal with the allegation against you, that we just make sure that you stay out of the neighbor's home. That's what you're accused of doing. You're accused of going in their home after being given a trespass warning, just walking in their home. That's what you're accused of. But you have very little, if any, criminal history. So I don't necessarily, I'm not opposed to a conditional release. I just need to make sure she's got somewhere to go. So, Mr. McDaniel, is it your understanding she still has, she can go to her residence, Mr. McDaniel? Do you feel like we're going to have problems if I let her do that? That's kind of putting you on the spot. I don't want to do that, but I want to make sure there's peace in the community there.
Correct. She can go to her residence. There's no issue with that. Will she walk off? I've dealt with these situations before, and with my grandpa, I don't know. It's these situations with people with mental health problems due from age-related mental health, they tend to walk off sometimes. I can't say that she won't walk off. I can say that, hopefully the sheriff's office would assist her and help the family, because, they get funded to do this kind of work. No one at the jail, no one at the public defender's office, state attorney's office gets some of that funding and stuff to help and protect and serve and help. But primarily the people that protect and serve with the sheriff's office. And, it'd be nice if they would take an active role and try to assist her, maybe getting into some kind of living, situation, maybe in a nursing home or something, because she does have retirement benefits. So, she's got money coming in.
Ms. Stevens, what line of work are you retired from, ma'am?
I used to watch children at MacDill Air Force Base.
Okay. And you're married, is that correct, ma'am?
Yes.
And you live with your husband?
Yeah, I married him in 1973.
Wow. I was born in 1971. So that means y'all been married over 50 years. What about, how old is he, ma'am? How old is your husband?
77.
How is his health?
Oh, he's fine.
Okay. Mr. Mitchell, what's the state's position on a conditional release in this case?
No objection to conditional release as long as we know that she's going back home with her husband.
So, Ms. Stevens, I'm going to offer you a conditional release. If Mr. McDaniel may have explained that option to you, ma'am. I just need you to stay away from this neighbor's residence, ma'am. And
Yes.
I know that you obviously right now are thinking very clearly, and we're communicating well. The police report says you were kind of confused when they interviewed you. So that you know, I have no doubt. Right now, I fully believe that you're going to do that. I need you to understand you got to stay away from that residence, ma'am. And whatever you need to do, write yourself a note or you know, get your husband to help make sure that happens. But I don't have a problem with the conditional release. So, Mr. McDaniel, would she like the conditional release, or would she rather post a $100 bond that's been set?
I think she would be fine with a conditional release.
I'm gonna make it easier. The only conditions of the conditional release are no new law violations and stay away from the alleged victim. It'd be a non-reporting conditional release. With her history, I don't see a need in her having to report in once a month. I just need to make sure that you stay away from the alleged victim and her property and have no new law violations. Those will be the only conditions of your conditional release. Knowing that, is that what you want to do, Ms. Stevens?
Yes.
Ms. Stevens, we're also going to give you a notice for your court date. Since she's not coming to the courthouse to be instructed, Corporal, I'm going to ask the jail to give her that notice. That will be for October 27th at 9 a.m. Ms. Stevens, you will not get a notice in the mail. Ma'am, the notice they put in your hand, in a few minutes will be the only notice you get. October 27th at 9 a.m. will be your court date. Ms. Stevens, do you have any questions?
No.
You'll get a chance to use the phone in a few minutes, ma'am, to contact friends or family to pick you up at the jail, and you'll be released in just a little while, okay?
Okay.
All right. Wish you the best, ma'am.
Thank you.
Yes, ma'am. Mr. McDaniel, that's everything I had on my first appearance list. Anything else at the jail?
Nothing else, Your Honor.
Corporal.
All right, since he's wrapping up, let's head to Texas. We'll say good morning to Judge Stevens.
States in paragraph 2 that in 2006 you were convicted of a DWI out of County Criminal Court at Law 11 of Harris County. In another allegation states on September 23rd, 2011, County Criminal Court number 11, Harris County, another DWI. And then in 2017, the 344th District Court of Chambers County, Texas, you were convicted of a DWI. So that's 2 or more. Paragraphs 1 and 2 constitute a third-degree felony, which means you face no less than 10 or more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? Yes. An agreement's been reached in your case where you would be pleading guilty and sentenced. Is that 2?
That's correct.
2 years in prison. Is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes.
And paragraph 2 of this indictment, which alleges these prior convictions of DWIs that we went over, are those allegations all true and correct? And are you pleading true and correct to those allegations voluntarily and because those allegations of prior convictions are indeed true? Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? State's Exhibit 1 tendered in? No. Without objection, admitted. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it.
Yes.
You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived here?
Yes.
I'm going to accept his guilty plea and find that the defendant is pleading guilty voluntarily, knowingly, intelligently. He's mentally ill. He's mentally capable and competent to enter his guilty plea properly. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt of this third-degree felony as described in paragraphs 1 and 2 of this indictment. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. Do you understand what has happened today, sir? I presume you're going to be taken into custody at this time.
Yes, Judge.
And you'll be given credit for whatever time you had served in accordance with this case. Okay? Thank you. That is all.
All right, let's stay in the building. We'll go across the hallway and say good morning to Judge West.
Juan Sanchez. And Mr. Sanchez is on probation in cause number 1830854 for the offense of driving while intoxicated, third or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was an unagreed, there was no deal, and I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report?
Not to the report, Your Honor.
Okay. And so with regard to Mr. Franklin, specifically, with regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one, I guess if it's an objection, that can be granted. With regard to number 2, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what I'm going to do in the case. I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled. With regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these. But it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor. Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record, and the court has reviewed those. I just
Yes.
wanted to note, for purposes of today, that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration in considering sentencing as well.
I will, and I did, and let me pull them up again just because I think that's been,
So specifically, they were not admitted for this purpose. They were admitted for bond.
okay, that's right.
For
Thank you.
purposes of bond.
Okay.
However, the letters of support, the
same,
information in
sure.
them speak to my client's character and
Yes.
his support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection, we would point out, as noted in the PSR, there is a substantial time in between the prior convictions and the current one for which he's on probation. And we hope that the court was able to look at that and consider that from 2001 to 2018, there was a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem, made efforts to be in compliance with probation. And although he did plead true to the current violation, he has shown 5 years of continued compliance. And we ask that the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols.
Your Honor, this case was originally pled as an 8-year cap. And I'd argued for Penn Diamond at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense and the new violations that are alleged that he did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision. I am in favor of revocation just because it is another DWI offense, Your Honor. But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it up again, in my opinion. You got this DWI, so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin, that shows that this was not an agreement. So you do have some rights to appeal. Once y'all sign that, I'll tear off that bottom copy for y'all if y'all signed at the bottom. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I'd said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment at 7 years. And here's that firearm, Mr. Franklin.
Thank you, Your Honor.
This is just going to go, this is to go in the pile after trial, yeah. And the bottom 2 copies are y'all's if you want to tear those off.
Okay. I think you pressed very hard, Judge.
That's okay, as long as my signature came through, I'm okay, because I get the top 2 with his on it. Give me one more of those. There's 4.
I'm so sorry.
Nope, you're good. Perfect. Thank you. All right, sir, you can go back with the bailiff.
Okay, folks, let's go back to Florida, but this is Anna Garcia, and I believe she's doing felony arraignments this morning.
-332. All right, Mr. Snowden, hello. Mr. Snowden, do you wish for the court to appoint an attorney to represent you on this new case? I'm going to appoint the Office of the Public Defender. Ms. Simpson is here from that office on your behalf.
Your Honor, on behalf of Mr. Snowden, we acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, schedule him to return December the 16th at 1 o'clock.
All right, we'll see you December the 16th. Keep in touch with Ms. Simpson, please. All right. Next case is Melissa Reno Wimberly. This is case number 24 CF 506. Ms. Wimberly, please come on up. And then will that wrap up your out of custodies?
Custody, I've got one in the bag.
All right, we'll talk about that too. Can you tell me your first name, the first person you called?
The first person I called, Adam Bruton.
Bruton, thank you. Ms. Wimberly, good morning.
Good morning.
Ms. Wimberly, you're here for an arraignment today in the case that I've just announced. Do you wish for the court to appoint an attorney to represent you?
Yes.
I will appoint the Office of the Public Defender. Ms. Simpson is here from that office on your behalf, okay? So listen carefully.
Your Honor, on behalf of Ms. Wimberly, we acknowledge receipt of the information and waive formal reading. We would plead not guilty and schedule her to come back on October the 21st. She indicated she may be hiring her own private.
No.
Oh, you want conflict
I
counsel?
asked the question. That's not what I
Okay.
said.
She may hire an attorney or not, but she needs conflict counsel because she has a co-defendant in the case that I already represent.
Oh, fair enough. Okay, so ma'am, you have every right to have an attorney and, an attorney that has no conflicts. Because your co-defendant is also represented by the public defender's office, then that's inherently a conflict that can be allowed. Some people waive it, but some people say, no, I don't want to waive that conflict. And so Ms. Simpson says, there's going to be a conflict. As a result, I want to get you a new attorney sooner rather than later. I'm going to appoint the Office of the Regional Conflict Counsel before October 21st. I want you to come back on October 21st at 1 so that you can meet with Ms. Amanda Kelly and get the ball rolling on your cases. That's why some people are coming back in December, but you're coming back in just a few weeks to get
What was
that
the
ball
name?
rolling.
Okay.
Oh, hey, Amanda. So that's
Hey.
Amanda.
Hi.
This is going to be a conflict that Wimberly, Melissa Wimberly.
Okay.
It's 24-506.
That's Amanda Kelly, and she'll be who I appoint you to see on the 21st. I have not appointed her
So I
yet.
gotta
though.
come back here?
Yes.
Okay.
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 All right. Amanda, anything you want to say to Miss Wimberly?
Ms. Wimberly, as soon as I get the information, you'll be getting a letter from my office with my contact information. If you haven't gotten it, I'd say within 2 weeks, give my office a call. Okay. Okay. Okay.
All right. Thank you, Miss Wimberly.
I don't have a card for her, but we'll send you, once the judge signs the order, we'll send that to you at the address.
Thank you.
You're welcome.
All right, Miss Simpson, who do you want to call?
I have Brendan McClendon.
All right, Mr. McClendon, good morning. Come on up.
This is case 2019-18 CF, Your Honor.
All right, Mr. McClendon, listen carefully to Ms. Simpson. I'm appointing the Office of the Public Defender to represent you in this matter. Go ahead, Ms. Simpson.
Your Honor, Mr. Gill is on this case and we've reached a plea agreement. I've had the opportunity to go through the court file carefully and I've spoken with Mr. McClendon. At this time, he would enter a plea of no contest to a charge of possession of meth, a lesser included offense in the original charge, and possession with intent to sell. He would be adjudicated guilty, Judge, and given 5 years DOC. He will be given credit for 5 years that he has already served on this case, Your Honor. The court costs and fines would be assessed by the court, and you may get a letter from the clerk's office about paying those court costs and fines.
Is this the agreement with the state?
It is, Your Honor, and I'm not aware of any exculpatory DNA evidence.
Does either the state or the defense, or Ms. Simpson, do you
No,
know of any exculpatory DNA?
No, Your Honor, I don't.
All right, and this is an older case. Anybody you need to consult with or
Your Honor,
any
I'll look at
concerns? All right, fair enough. Mr. McClendon, please raise your right hand. Sir, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Tell me your full name for the record.
Brendan Devontae McClendon.
Thank you. You can put your hand down. Did you hear what Ms. Simpson just said about resolving your case?
Yes, ma'am.
Is this how you choose to proceed?
Yes, ma'am.
Has anyone promised you anything other than what Ms. Simpson said to get you to enter into this plea?
No, ma'am.
Is anyone threatening you?
No, ma'am.
I have in front of me a 2-page plea waiver and consent form. This is the first page. This is the second page. Did you sign that document right there?
Yes, ma'am.
Did you have enough time to review this 2-page document before you signed it?
Yes, ma'am.
Have you had enough time to talk to Ms. Simpson?
Yes, ma'am.
Are you satisfied with her advice and with her counsel?
Yes, ma'am.
Do you understand that by entering into this plea today, you are giving up your right to go to a trial where the state has to prove you did what they say you did? You're also giving up your right to present any defenses that you may have. You're giving up your right to appeal anything except an illegal sentence, and you're giving up your right to participate in the discovery process.
Yes, ma'am.
Is that what you want to do?
Yes, ma'am.
All right, then I find that your plea is knowingly and voluntarily entered into after the advice of counsel, and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. McClendon in Jackson County, case number 19 CF 18. I accept. Guys, whose phone is that? I need whoever it is to please turn that off. Okay, guys, turn off the phone. Okay, thank you. Please do so. And if you can't, then please step outside. Okay, let me rethink. In case number 19 CF 18, I accept your plea. I find that it's knowingly voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. McClendon in Jackson County, case number 19 CF 18, I accept your plea of no contest to 1 third-degree felony count of possession of meth, 1 third-degree felony count of possession with intent to sell marijuana, I would assume, right?
Yes, Your Honor.
I adjudicate you to be guilty of each of the charges, and I sentence you to serve 5 years in the State Department of Corrections in each count concurrent with each other with credit for 5 years that you've already served towards that sentence. I order you to pay court costs, fines, and fees in the amount of $1,100. Those will be reduced to a civil judgment. I order you to forfeit all items that were seized.
Okay.
This shall be served concurrent with case number 16 CF 216, Santa Rosa County case number.
Yes, ma'am.
Anything further from either the state or the defense on this case?
No, Your Honor.
No, Your Honor.
All right, Mr. McClendon, I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose, okay?
Yes, ma'am.
All right, Mr. McClendon, good luck to you.
Yes, ma'am.
And we're going to need your fingerprints.
You gotta go right over.
All right, let's do our 9 to 11% more, Judge Boyd. Let's get that going.
So the last time we were here, on September 29th, he pled not true to violations 1 and 1. So is that still the case?
No, Your Honor. My client wishes to change his plea to true to both the allegations.
Right. So we're going to go on the record. The court is calling 2019 CR 8096 State versus Austin Zachary Mark Gibson. Can I have parties announced for the record for the state?
Lauren Espinoza.
Andrew Fraley to the defendant.
And are you Austin Zachary Mark Gibson?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Austin Zachary Mark Gibson who was placed on deferred adjudication in 2019 CR 8096 for the offense of aggravated assault with a deadly weapon on February 21st, 2020 for a period of 7 years? Is that you?
Yes, Your Honor.
All right, state.
Your Honor, violated condition number 1 on or about the 31st day of August 2025 in Bexar County, Texas. The defendant, Austin Zachary Mark Gibson, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that?
True.
Violated condition number 1 on or about the 31st day of August 2025 in Bexar County, Texas. The defendant, Austin Zachary Mark Gibson, committed the offense of criminal mischief greater than or equal to 750 less than 2,500 in violation of condition number 1.
How do you plead to that?
True, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes.
Court will find violations of conditions 1 and 1 true. State, what are you recommending?
Your Honor, at this time, state is recommending that you grant state's motion to revoke, enter an adjudication of guilt, and sentence to 7 years in the prison.
And defense, what are you requesting?
Judge, we're requesting to continue. My client would like to address the court.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Austin Zachary Mark Gibson.
All right, so what do you wish to say to the court?
I just want to tell you that I do accept a full range of, full responsibility for it all, and I do apologize to you and the court, and the persons of that business. I did react like this due to, lack of consistency on my medications. I do ask that I can get the help, to get this correct. I have a meeting scheduled with Miss Amanda at CHDS. I apologize. I'm going to ask a couple of questions and go back. Before we talk about Amanda from Center for Healthcare Services, talk about what happened. You said you were inconsistent on your medication. Yes. You want to be more specific? A lot of the inconsistencies would be, getting up very early for work, like 3 a.m. I wouldn't, out, just pack my lunch and out the door. Being there's time that my phone isn't charged or plugged in, or even the noise, because my little girl would like to grab my phone. And so you basically stopped taking medication. Yes. And ever since you got clean and sober, when did you get sober? I've been sober for a good while. Ever since you got out of Lifetime, pretty much? Yes. With one minor exception, but you've tested negative on your UAs since October of 2024. So basically for the last year, you've been all negative on all your UAs. Yes. And you successfully completed Lifetime Recovery inpatient. Yes, sir. Successfully completed SATF before that. Yes. You had done the outpatient program before. Yes. Completed your UAs in the last year successfully. Done private outpatient with Lifetime, is that correct? Yes. And you're behind on your fees though, is that correct? Yes, but I do have employment. Yeah, but go ahead. I do have employment that I can catch that up. I did have a vehicle that had a lot of issues, and it took a lot of my money, and that's why I couldn't stay consistent on the payments. But this job that I do know is a second chance employer. They have accepted me for employment. And so since you got off your medication, that's the real problem you're having. Yes. And what happened with this specific incident? It was just time of day. It was hot. I just got frustrated. I outlashed towards just an inanimate object rather than a person, and broke the fence. And I was looking for water for my radiator because I thought it was the radiator that had failed, but it was the water pump. So I tried to put water into the reservoir so that it could feed back into the radiator, but I didn't find nothing but like maybe a quarter of a cup.
So, but what happened was you were trying to fix that.
Yeah, I wanted to fix that and, I couldn't find a water faucet that worked. So I said, oh, you know what? I already broke the fence. Let me go to the roof. Let me see if I can find a run valve for the HVAC system. Well, I found one. I tried to turn it and it didn't work. So when I stood up, I slipped and I kicked the piping right there.
And what does that have to do with you being off medication? Talk to the judge about that.
That's just, me. My mood swings have been, it's been a lot of up and down. And I never really understood how to talk to anybody about that. I would like to try to talk to my team there at the Center for Healthcare Service, but when I do call, a lot of the numbers, either when I call, they answer and hang up, or it sounds like a fax machine, like a beep boop beep boop boop.
I have a question.
Yes, sir.
You've been before me previously for a violation of condition number 1.
Yes.
And whenever there's a violation of condition number 1, that's a new charge. So what was your previous violation of condition number 1 for?
I can't recall.
All right, could somebody look that up and tell me what that previous number 1 was? Because once you had a violation of condition number 1 for that time, the court denied the motion, and that's when you got sent to lifetime recovery. And the motion was withdrawn. So there was a previous number 1. Yes, what was the previous number?
In 2023, the new offensive assault was withdrawn on 2023, and conditions were amended to include drug court, lifetime recovery.
All right. So that was an assault. And who was the complainant in that assault?
It was my wife.
The name?
Claudia. Russian.
Yes. And now I have a letter, defense exhibit number 1, with her saying, there were some issues between you as far as you're not doing your medications.
Yes.
All right, continue. I'm just trying to get the sequence of events in my head.
Yes,
all right.
And it's just been there's not much else I could say about it. It's just, I've had a lot of, problems within myself trying to find, either courage or, cry out. I'm not sure, but I didn't know that I could even come to you. A lot of people told me in the jail that I could ask you.
No, because let me just tell you, let me stop you right there. You're saying that you can't come to me.
No.
I don't believe that. And let me tell you why I don't believe that. And your counsel will tell you this. Everyone in this court who is placed on probation, I let them know. If they have an issue, let their officer know. If they feel as their officer is not addressing it, then you can come back to me. And every time that somebody's had a motion to revoke, if I've continued them, I tell them that. So don't start with, I didn't know I could come, because that's not true.
Yes. Yes. And my plan is to get with Miss Andrea at Center for Healthcare Service, and explain to her my, issues that I've had personally, and see who she could get in touch with, like with the care team over there that I can follow through with.
Austin, if I could interrupt you, you met with somebody 2 weeks ago from Center for Healthcare Services since you've been in custody. Is that correct?
Yes.
And when you met with her, she talked to you about if you're released, if the judge is kind enough to continue you can go to Center for Healthcare Services.
Yes.
And they will plan a treatment and care team around you.
Yes.
That's what you told me.
Yes, they will.
So it's not so much of, you're going to talk to her when you get out, but you've actually met with her and.
Yes, and she's told me and 4 other gentlemen that they would do that.
And so what you're asking the court to do.
And I'm asking the court if you could kindly reinstate, if not, I accept full range of the punishment of my problems here.
All right. State, any questions?
Briefly, Your Honor. Mr. Gibson.
Yes.
At any point during this inconsistency you refer to, did you inform your probation officer?
Say again?
At any point during this time of inconsistency, did you inform your probation officer of that inconsistency?
It's been she's a very hard woman to get a hold of. start with. So, I mean, I would like to talk to her. Like I would want to tell her things like that, but she would always say like, no, it's not. That's not for me to deal with.
But my question is, did you make attempts?
Yes.
Okay. And then prior to August 31st, 2025, did you have contact with Center for Healthcare Services regarding this inconsistency? Or did you make attempts to?
Yes.
Yes. You mentioned that you were attempting to get water, correct?
Yes.
On or about August 31st, 2025, was the Wallace Bank open?
No.
Were there
I
other
don't think-
businesses around?
There was a Jason's Deli, I believe, but I had asked somebody like from the parking lot, like, hey, can you help me with some water? They looked at me like I was crazy, so I was like, I'm not even gonna attempt to.
Would you agree with me when you jumped the fence for the Wallace Bank, you had 2 jugs of water with you?
No, I had an empty bottle.
So at no point you didn't pour water on yourself throughout the
I
time?
poured water on myself, yes, but it was that was very hot water.
So you would agree you came to
Yeah,
the Wallace Bank with
yes,
water?
with water, yes. But I needed more water.
Mr. Gibson, would you agree with me the best way for someone to learn a lesson about consequences for them to take full responsibility for their actions?
Yes.
No further questions.
Nothing further.
All right. So probation, on this case, can you tell me, was there any restitution that was due Vincent Arias and Victor Toro? All right, so Mr. Gibson, what I can tell you is I read the letter from Ms. Rushing. There is nothing else I can do to help you. And let me explain to you why. This is not your first motion to revoke. And each motion to revoke that you've had with me has been your having a new case. So the first time, you're of course on deferred adjudication for aggravated assault with a deadly weapon. And the first time was an assaultive case against, you say, your current wife. And that motion was withdrawn. I'm assuming it was withdrawn because maybe she didn't want to come forward, or maybe there wasn't enough evidence. I'm not saying either way. I'm just saying that with regards to that issue was addressed by withdrawing the motion. And when that motion was withdrawn, the first thing was a referral to felony drug court. And if you were not accepted there, a referral to lifetime recovery. And before that, you were sent to SATF. So there is, and then, well, actually, you've had more than one motion to revoke. So you had a motion to revoke in 2020. That was a violation of condition number 1. The court found that true after your plea of true. You were denied an alternate amended with a TAP evaluation follow recommendation. Then on November 2020, you're like, hey, I'm ready for treatment. Let me do it. And I said, okay. And that's when you were with your new wife, and there was supposed to be no harmful or injurious contact with her. And then after that happened, then there was a motion to revoke that was withdrawn, and they alternately amended conditions to include no contact with Claudia Rushing. And here we are with another number 1. And based upon the state's cross-examination and your answers, this wasn't about your seeking water. You had 2 jugs of water, and you actually poured water on yourself instead of pouring it in your vehicle. So as previously stated, the court is finding 1 and 1 true. The court is going to find you guilty. The court will revoke you. There's an affirmative finding of deadly weapon. There's to be no residing in any household with minors.
Why is that?
There is to be no unsupervised contact with minors. And the court is going to have the previous conditions that were previously given. There's to be no contact with Claudia Rushing Vincent Arias. And Victor Toro, I think it's Tovar, Tovar. And the court is going to sentence you to 10 years in the prison. The court will give you credit for any time served. Credit for any time served for successful completion. Thank you. All right, if you'll let the clerks know. Successful completion of inpatient treatment. Court will recommend therapeutic community. Therapeutic community doesn't increase the time that you're in custody. It's just to provide you with help with your sobriety. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication.
Quick question.
Sure.
That my wife is all I have out there, and I understand that, you know, what I did was wrong, but she's the only person I have.
So here's the thing. I understand what you're telling me, but what I'm telling you is based upon the allegations of your previous assault against her. You all agreed that the motion would be withdrawn, and this is from 2023, I believe. You agreed that it would be withdrawn and that there be no contact with her. So the court is following the previous condition.
Please let me at least talk with her, because that's my daughter, you know. That's my family. That's all I have.
No, she, in the letter that I received, she states in that letter that those are her biological children, not your biological children, that you have a biological child with someone else.
No, it's with her.
No, that's not what's in the letter.
With Claudia? Yes, I have a little girl, Athena Gibson.
That's
with
not
her.
what she put in the letter.
Yes, I have a biological daughter with her, Your Honor.
Well, what I'm telling you is when you're released, you're not allowed to have any contact with her. When you're at the prison, you're not allowed to have any contact with her. You're not allowed to have any unsupervised contact with minors, and you're not allowed to reside in any home where there are minors. And that's based upon the letter that was presented to me. That's based upon your current actions.
And Judge, could we modify that to allow him to have contact with his biological daughter?
No unsupervised contact with minors. All right, thank you.
Yeah, these are always so unfortunate when somebody just can't seem to figure their stuff out. I mean, you get what you deserve. That's for sure. I just wish more people could figure out how to get their lives together. But, you know, I can wish all day long. It does not make it so. Let's go back to Judge Stevens. Looks like he might have a new contestant.
Aggravated assault and assault family violence children.
Thank you. That was good. That was very good. Yes, sir. That was good.
And the other two cases are 21-36667 and 22-40505. Those are to be dismissed, correct?
Correct, sir. Yes.
All right, on these two cases, does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, sir.
In summary, 21-36668 alleges that on or about September 6, 2018. In fact, we're going to take them both together, okay? 36668 and 36669. They similarly allege that on or about September 6, 2018 in Jefferson County, Texas, in 36668, it goes on to allege that the defendant intentionally and knowingly threatened the complainant with imminent bodily injury by putting a firearm to her head and then in their use or exhibit a deadly weapon, namely a firearm, during the commission of this aggravated assault. It is a second-degree felony, which carries with it, if convicted, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Do you understand what you're charged with in that particular case, 36668, Mr. Woolley?
Yes.
And in 36669, it goes on to allege that in Jefferson County, Texas, on or about September 6, 2018, the same date, that you intentionally and knowingly caused bodily injury to the complainant with whom you had a dating relationship as described in the Texas Family Code, and intentionally, knowingly, and recklessly impeded the normal breathing or circulation of the blood of the complainant by applying pressure to her throat and neck and blocking her nose and mouth. That constitutes the third-degree felony of assault, family violence by choking, which carries with it, if convicted, no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. You understand what you're charged with and the punishment range with that, please, sir?
Yes.
Agreements have been reached in your cases where you would be placed on in 36668, you would be placed on deferred or unadjudicated probation for up to 10 years in length. 2 other cases would be dismissed, 21-36667 and 22-40505. I don't think that came out on the pad because you ran out of room, looks like.
There's also dismissal of a misdemeanor.
And then an appeal will be dismissed in 21 dash. I don't know what that one is. I can't read the number. The number's not reading. We're gonna have to correct those, okay? The first thing on it, that other case that's gonna be running concurrently at 22. Yeah.
It's F21 dash.
No, give me the 22 that the 40505. Let me write that because that didn't come out. Right. And then the appeal is going to be one.
F21
Okay.
dash 37528 dash 0.
We can't get new pads fast enough. Look at that. I write it and it just came out.
That's why I was in the
It was in seconds to show up on the pad after you write it. Okay, I've got 37528, but there was something, a dash.
0.
Okay.
Did you get that misdemeanor also?
No, I don't have anything on that. I mean, this is what I have.
We didn't write the misdemeanor.
This is what this.
Oh, that's okay. I'll send a message to him, Judge. I'll get that taken care of. I'll put it on the record that I'm dismissing.
668. Is that your understanding of the agreement, Mr. Wood?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to that indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
It's acting funny today. In 36669, This again alleges that you committed the third-degree felony of assault, family violence by choking, which again carries with it a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You acknowledge, you understand that?
Yes, sir.
And an agreement's been reached in that case. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there will be terms and conditions of probation which are normal and customary for that type of offense. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, or guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked in each of these cases as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 in each case tendered into evidence and without objection?
Yes, sir, no objection.
Admitted. In each of these cases, the State's Exhibit 1 similarly state that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. The indictments, the charges have been read to you. You understand them fully. You are guilty of the crimes charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All of this is states true, so help you God. State's Exhibit 1 in each of these cases made a part of the record for all purposes. Pre-sentence reports away.
Yes, sir.
Yeah.
Anything to add by anybody?
Yes, Judge, as part of the conditions of probation, the state's requesting that the victim in this case still has some fear for her safety with the defendant. So we'd ask that he remain at least 500 feet away from the address of 6975 Burlington Drive, Beaumont, where she resides. Also where she works at Bayou Bar on 5198 Finette Road in Beaumont, and Red's Ice House, 7665 College Street in Beaumont, Texas. Those three addresses, if we could just, and we also asked that for a while, that until we feel secure, that he maintained his GPS for a little bit.
We'd rather not have the GPS, but the other items, no objection. He's had the GPS for what, 2 years, something like that?
Yes, sir.
Yes, sir, and he violated it this weekend, so.
Arguably, not.
Well, we've got video and GPS that I could provide to the court later on. We looked it up this morning, and I have a video provided by the victim in this case. While she was out at the river, she saw him on a boat, and he's supposed to be under house arrest. So that's a violation of his bond. It's not a violation of his conditions of probation, but because we didn't have him under house arrest on probation. But I just feel safer with him. He's not really been serious about it, and I want to make sure that he keeps it on for a little while till probation feels secure with it.
What's your response to that?
My response is that, except for what he's talking about this code situation, I don't know who we're going to actually try this issue.
Surprise.
But that was hooked to the bond, and he went out there to fix a boat, and what can I say? He's been on the GPS.
Were you supposed to alert somebody though?
Yes, sir.
When that happened, did you do that?
Yes, sir. I actually met with Sarah Simon yesterday, but I have been working on, I got 3 boats. I've been working on many of them down at the marina and on the river. I've put in an itinerary, and she says she gets it approved by you. She's been my contact, and she said, yes, I'm okay. She is clear not to pull up
it didn't go through me.
Oh, well, she told me that it was clear to go, and that if I need to shore my boat because I had oil leaking, to shore it where there are no kids. And in the video, you can see there's no kids. I'm at a sandbar by myself with the engine up and cowling off, trying to secure the oil leaking out of the rear.
And the photos
And I
should
video
all kinds of oil running. But it seems to me like, of course, I haven't lived and breathed this case like you have. He's been on the thing for 2 years with the GPS, and I don't know, is it really necessary to continue on? No, whatever you think, Your Honor.
What are you asking for?
I'm just asking the GPS remain on, that he remain away from the complaining witness within 500 feet of where she works and lives. She's had, as you can tell, with the number of cases that were filed, that she's had some fear from this gentleman for a long time. And we just want to make sure that at least for a while till probation feels secure that he's following the rules and everything, that that GPS remain on.
I'm going to keep it as a requirement, as a condition of probation until the court deems otherwise. Actually, these are the most serious kinds of allegations, sir, I've read in. You can't treat a lady like that or anybody else. Shame on you. You pleaded guilty to two crimes. They carry with it to up to 30 years in prison. And these are one is an aggravated offense, and the other is a family violence by choking. And everybody knows what that means. When you squeeze somebody's neck, there's only one intent: not to love them, but to hurt them, harm them, and threaten death. We all know that. It's why civilized people don't take.
Judge, also there was
those kinds of actions to us.
In the previous case that he was convicted of by the jury that they're dismissing the appeal on, cause number 2137528. The court assessed 180 days upfront jail time on that. And if they're going to dismiss it, we kind of need to decide when we're going to start that 180 days.
The order says weekends. It started some of those weekends in the top field.
No, it starts again.
Yes, sir.
Yes, sir.
On or before 6 o'clock each Friday. Then that's 90 weekends.
Yes, sir.
Yes, sir.
And that's ordered. All right. Are there any other from the state? Before we, from the state of Texas, Mr. Laird?
I'm sorry.
I know you got a lot going on.
Yes, sir.
Are there any other conditions of probation that need to be addressed as we're signing all of this? Because I never get amazed at what additional problems are coming up. But is there any other?
No, sir. He was under house arrest, but I don't know.
Safety of the, I'm more concerned about the safety of the complainant.
Yeah. And we've got that. We're going to put that geofence. We're going to contact the people that keep the monitor and let us know if he gets near.
Yes.
The probation, if it's violated, you know what happens.
Yes.
You can be found guilty.
Yes.
Then sentenced up to 20 years on one case, up to 10 on another.
Yes, sir.
Anything else?
As far as the weekend starting, he should coordinate with the probation department.
You can start this weekend.
Yes.
Tomorrow. What? No, Friday.
Right. I mean, as far as the jail having note that he's going to show up.
I'll do a memo.
Yeah, we learn them. Yes, sir.
Okay.
I also need thumb purchase to be sure.
Okay. Do you need to see him any further on anything like that?
I need an operating.
Okay. Please see her, sir. Thank you.
All right, we interrupt our current courtroom broadcast to congratulate one Michael Groff. As you'll see on your screen, this is Michael Groff's channel. He just hit 3,000 subscribers. And look, Michael is one of the most talented people that I have ever seen in the space. He's incredibly good at what he does. His content is a little more niche, so it is going to take him more time, perhaps, to really roll up the subscribers into the tens and hundreds of thousands. But It doesn't have to take him forever if we all give him our help and support. So if you're not already subscribed to Michael, please do so. Just watch one of his videos and you will understand why this man needs all of your support. So congratulations, Michael. You're really good at what you do. I've learned a lot by watching you myself. Appreciate all you do to help me, and congrats, and hopefully we get you doubled here in a month. That'd be super cool if we could find a way to make that happen. So let's all help him out. And speaking of Michael, check out this live show tomorrow morning. That's all I'm going to say. Just be here tomorrow. All right, let's where do I want to go? Let's go back to Judge Boyd.
And that's for discovery. All right, the court is calling 2025 CR 007922, State versus Jesus Suarez Marino. I believe this is family violence. All right, can I have parties announced for the state? Defense?
I'm here by the end of the defense.
And are you Jesus Suarez Marino?
Yes, Your Honor.
All right, so his current bond is set at $125,000. What are you requesting for the reduction of bond?
Well, Judge, I think 50,000 would be fair.
All right, so you're requesting 50,000. And state, are you going to be opposed to the reduction?
Yes, we are, Your Honor.
All right, defense, do you have any evidence?
I do, Judge.
Yes.
But my witness is unavailable today, so I will need to withdraw the motion or reset it for another day.
All right, when will your witness be available?
I have to get a hold.
All right, so what we can do, is your witness able to appear by Zoom?
Okay.
All right, are you going to object to their witness appearing by Zoom?
No objection.
All right, so if you'll speak with Ms. Ferguson, and that way we can take care of it today. If you feel more comfortable with them being in person, just let us know. We can reset it, or otherwise they can appear by Zoom.
I would prefer to reset it.
All right, so Ms. Ferguson, this motion will be withdrawn, and we're still on the record, correct?
Yes, ma'am.
All right, so defense, are you withdrawing the motion to reduce bond?
I am, Your Honor.
All right, the motion will be withdrawn. Thank you.
Thank you.
You're welcome.
All right, quick little hearing there. Let's continue in Texas. Go back to Judge West.
Good morning, sir. You're Alfredo Gayton. And Mr. Gayton was previously in court in cause number 25 DCCR 0184. Entered a plea of guilty to driving while intoxicated third or more, which was enhanced to a second-degree felony because of prior offenses. The agreement was for a cap of 14 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections?
No, no,
All right, Mr. Parker, you may proceed.
Just some of my client's knowledge. I've given the court and the prosecutor a letter of support from Frank Maida.
And I've received that and reviewed it as well.
And Your Honor, from talking to this man, talking to people that have known him, he is a good person that's just an alcoholic. And I think he was, I think he was pretty honest in his PSI. He talks about drinking at the age of 11, then 14, and then get to the point where he drank, at least a 12-pack regularly. He drank tequila and Crown Royal regularly until the point where he passed out and could never get enough. He's had several DWIs in the past. He's never had any kind of help at all. And I think he is a prime candidate for safety to get the help. He's had some periods where he's tried to do it on his own, and he was somewhat successful. He cuts grass for a living for several people here in Beaumont. He has the ability to make money if he's given the opportunity to be put on probation and go to the safety program. So he can do that. And it looks like to me that the PSI is also in concurrence that he would benefit from safety. And I just think that's the best thing for him instead of just locking him up.
Thank you, Mr. Parker. Ms. Malfino?
Judge, I think it goes without saying that he certainly could use the help of safety. I think it also has to go without saying that priors, the criminal history that cannot be ignored. Obviously, of course, we'll defer to whatever the court deems appropriate. I respect Mr. Maida's letter. I take him at his word. But it's just difficult for me to argue both ways because I think he needs the help, but I also think we have the criminal history to take into consideration.
Right. And again, I mean, I think most of his criminal history is just drinking, and so many people have got the opportunity and it's worked for him, and he, you know, not from anybody's fault, you know, he's never got that help, you know. It's okay. Is there anything you want to tell the court?
They sent me to prison and made me work and work and work. They never teach me as drinking, and I always go for games. I'm always making this to trustee, and I'm working on the freeways with Texas Department of Transportation, cleaning the roads, do anything, and disasters. Never give me a chance to stop.
But if you've gone to prison 3 prior times.
Yes, ma'am.
For DWIs, 3 times you've gone to prison. So this is your 4th felony DWI.
Yes, ma'am.
This is your, at some point, when you get out of prison, do you say, I need help and I'm going to get help for myself, instead of saying somebody else didn't help me?
I never had a chance. I have to look for work and.
But I know, but you have people like lawyer,
Yes.
Attorney Maida. You could have said, hey, I need some help. You know people that can help me. I don't want to go back to prison.
Well, finally, this time I end up on the right city with the right people. Create a really good reputation. I met Mr. Maida, Dr. Suri, and a lot of good people, and they check my background, and Mr. Maida said my wife and me discuss, and we willing to give an opportunity. I've been working for them for years now.
Yeah, I just to make more clarity, I think that when he came here and he was working for the people around here, there were some things that he was doing, and he was not drinking. I don't remember the incident, but there was an episode where he started drinking again, and it was pretty close to the time frame. This wasn't I'm not saying this is the only time, but he had started drinking again. And I don't take it that he was blaming anybody for not giving him help. He just said he's never had that opportunity. And, you know, when you're an alcoholic or a drug user or addicted to anything, it's easy for, you know, to say, it's the same thing with an abused woman. Why don't you just leave? Why don't you just leave? Just learn,
But
stop drinking. And it's hard, yeah.
I don't disagree that it's hard. But I also, if you'd never been to prison before.
Right.
And if you hadn't had the wake up call of prison to say, I don't want to go back to prison. I need to figure out how to stop drinking. And then you get out and then you do it again. Well, I didn't figure that out. Let me go do it again. Your blood alcohol was 0.257. You ran off the road. You could have, I mean, there's just too many times that I see now, unfortunately, people in here where we're looking at someone who is, has killed someone or hurt someone. And the fact that this is your 7th DWI, it's your 7th. I don't disagree that you need help, but I don't feel like now's the time for, and I don't know what happened in those cases in Harris County and Bexar County. You know, if you were given an opportunity, at some point, I feel like there's opportunities for probation where people decide not to do that because sometimes doing a few years in prison is easier.
Well, I think
it's
some of
odd to me that there has not been a probation.
I think some of these he sat in jail and wasn't able to bond out, and it's one of those deals, you know, we'll plead you to 2 years or 4. I don't remember the numbers, but, and so.
I mean, you got 12 years back in 2004, 12 years for your DWI, 2nd felony DWI. Then you got another one after that, and for some reason Bexar County, said, well, let's give them less time. Let's give them 5. Let's reward them for continuing the wrong behavior. Anything else?
I mean, the same thing. I just see people that, I mean, it's, you know, I concentrate solely on the fact that his criminal history is alcohol. And there are people that we've seen on their 4th or 5th that we've given safety to, or people that are on probation. People are on probation for DWI and they violate the terms of probation by drinking, and they come back before, I mean, all these courts, and several times we say, hey, let's give you safety, you know, and I can make the same argument, you know, you just went to court, you know, I mean, I don't, I mean, I get it, but I don't get what people think. But I just think he's a prime candidate for safety, and he would benefit from it. He's a good person. He'll work. You know, but I understand the court's position.
Yeah, sure.
I've been so
I'm sorry?
I've been sober since the accident. I moved to a small chair.
You've been sober since the accident?
I moved to a chair that is on the back of the property, Mr. Maida, and he said one condition, no drinking. And I respect that, and I've been doing exactly what he says. Because I know he's the only one of the few persons that believe in me, and he's given me a great opportunity. I know it's the chase of my
I can't,
life.
slow down.
He said he's one of the only ones that will give him an opportunity. He knows he's serious about it. He's allowed him to move on the back of his property in a little room, I think.
We even went to what they call a retreat. He asked me if he was willing to go, and I said yes, sir. And we spent 3 days, and he's a great person. He's been helping me a lot.
So here's the thing. If I even were to consider, which I'm not sure why I'm even considering, but I might, giving you a probation, you would not drive ever a vehicle.
No, ma'am.
I mean, it would be part of your probation. So you're going to have to,
No, ma'am. I
ever.
haven't get a car.
Listen to her.
I mean, it would be a condition of your probation that you never drive the entire time that you're on my probation. I mean, you understand that?
Yes, ma'am.
So,
Judge, if it would help the court, I'd be happy to try to get with the probation department and get with those other district attorney's office and see if there's ever been a probation on any of those cases that have been subsequently been violated.
I think they typically are listed in here that way. And so it doesn't appear that there ever has been one. I guess one of my dilemmas now is if I do consider probation, it would have to be a straight probation and only for the 10. And I lose that opportunity that I have today to give up to 14
Well, you could
years.
possibly, one thing we could possibly do is sentence him to 10 over 10, give him 180 days up front and hold that in abeyance as a condition. I mean, which just extends it more. I mean,
Nah,
like a,
I don't know that it really extends the time. It just gives them time
Right.
potentially.
yeah.
Okay, here's what I'm going to do, Mr. Gayton. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to give you an opportunity today that you have not had, but there's going to be some conditions on this probation, and you will be on 0 tolerance. And what that means is that any violation, is going to get you right back in here with the sentence that I'm giving you today. I will make a notation. There will not be plea agreements on a motion to revoke your probation. If you violate and I find that you violated, that's it. You're done. Do you understand? So I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You're on probation for 10 years. I'm going to order as a condition of your probation that you enter and successfully complete the SAFE program. and that when you're released as part of the aftercare, you will then enter and successfully complete the JCDI program, which is an outpatient program. You will be ordered not to drive any vehicle ever whatsoever. You will also be ordered to wear at all times a scram device. That's a device that will tell me if you have alcohol in your system. If you test positive on that, when you get out after SafeP and you test positive for alcohol, you will immediately be back in here and go into prison for 10 years. It's that simple. It's the length of time that you have been an alcoholic. This is going to be a very difficult process, but either you want to do it and go through that difficult process, or you want to spend the rest of your life in prison. So that's going to be up to you. There's no, I relapsed and this is a difficult thing, and I understand that. This is it. You will be ordered to serve 10 days upfront time as a condition of that program. That's required. You'll obviously get that time in while you're waiting to go to SafeP. Anything else condition-wise that anybody can think of? I'm sorry. I'm going to order a $500 fine. All right, so I think that covers it. And so, Mr. Gayton, I hope you take advantage of this. It sounds like you're ready finally at this point in your life. I hope you take advantage of it, because again, this is the only opportunity you're going to get here in this court.
Thank you, appreciate everything.
Have any ability to pretty tightly monitor his no driving? I mean, I know that's just.
I don't know how to, because if I put, a GPS won't do it, because if he's in somebody else's vehicle, I mean, I'm inclined to reach out to,
Maybe some of those people who have reached
yeah,
out for him.
so I'm inclined to reach out to Mr. Maida and explain to him
I will explain to
about
him.
the no driving, because I know Mr. Maida is the one that helped get him that vehicle in the first
Right.
place that ended up, I think, part of this wreck.
Right.
But when I say no driving, it doesn't mean in a couple of years I get some request that, hey, he's been doing great, let him drive. You're either riding with someone, or you're on a bike, or whatever else, or walking. And that is the most serious part of what I want and need to do to make sure that the community is safe. Do you understand?
Yes, ma'am.
Okay. I don't see the certification. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, Mr. Gayton. I hope you take advantage of this. Don't make me regret it, please. Okay.
Thank you.
Well, nobody bats 1,000. That's for sure. 99% of the time I line right up with Judge West. I think most of us do. We appreciate the effort that she puts in and appreciate her courtroom. I think this one was a miss. I hate 10-year probations because nobody ever makes it. It's just too long. It won't work. And hopefully, nobody else gets hurt. I could be wrong. There's always the diamond in the rough. Somebody, steps up and gets it done. I just wouldn't count on it. Anywho, that having been said, let's go to Tennessee. Judge Wolf is in Humphreys County this morning doing a criminal docket. Let's see what he's got going on.
And I also have a signed plea petition that I'm tendering. Mr. Vibbert is going to be entering a no contest plea to counts 1 and 2 of the indictment, both violations of the sex offender registry. In count 1, he'll receive a sentence of 2 years TDOC suspended on time served to supervised probation. He would be assessed and I say on time served, there's a 90-day, he's done more than that. He would be assessed a $350 fine plus cost. He would have to comply with the sex offender registry requirements and passing drug screens as a condition of probation with 0 tolerance for failures. And count 2, he would be sentenced to 1 year TDOC suspended supervised probation consecutive to count 1 with the same conditions of probation as are set forth in count 1. He would receive jail credits from April 30th of this year until present.
All right. Mr. Vibert, is it Vibert? Vibert. Vibert. Mr. Vibert, raise your right hand. Let's push you on the road.
You solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am. State your full name for the record.
Jesse Vibert.
Mr. Vibert, you are here today charged with violation of the state sex offender registry on 3 different counts. You have seen or been shown a copy of those charges, talking over with Mr. Simpson. You and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated you want to enter a plea of novo contendere. That just simply means you understand the state's evidence. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence, and I will then use their evidence to find you guilty according to this agreement. Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed for you if you cannot afford your own?
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that at trial, you and Mr. Simpson could confront and cross-examine all witnesses the state calls to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal, and that all I'm going to do is approve what your lawyer says. You understand that's, you need to speak up just a little bit. We're recording all of this. You understand that's going to result in 2 additional felony convictions that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you.
Yes, sir.
You want to plead no contest according to this agreement and waive your right to a trial.
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it.
Yes, sir.
Then let me ask you to listen as the state tells me what their evidence would be if this case went to trial. Step to one side so that you can speak into the microphone.
Yes, Judge, if this case had gone to trial, the state would expect to be able to show that back on April 11th of 2025, Officer Ravon Weems, who is supervising Mr. Vibert because he's on the sex offender registry, became aware that he had social media accounts in violation of his requirements under sex offender registry statute. He had Facebook, which was not made known to her. She had no idea that he had that, but she became aware of it and was able to verify that it was his Facebook account. She also became aware that he had a Snapchat that, again, he had not made her aware of, and that she did not have listed as any account that he had while under her supervision. Those are the facts.
Mr. Vibert, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
I feel like Mr. Simpson's done a good job of representing you competently.
Yes, sir.
Mr. Simpson, you know of any reason you should not enter this plea?
I do not.
Then Jesse Vibert in docket number 15127, upon your plea of no contest to count 1, I find you guilty, sentence you to 2 years Tennessee Department of Corrections that would be suspended on time served to supervised probation. You're ordered to pay a $350 fine and court costs. You must comply with the sex offender registry requirements and pass all drug screens with a 0 tolerance. That means 1 positive drug screen will violate your probation. Count 2, you're found guilty, sentenced to 1 year of Tennessee Department of Corrections, suspended to supervised probation consecutive to count 1. Those same conditions as count one will apply. Count three is dismissed as part of this agreement, and you're given credit for time served from April 30th, 2025 until today. Please see the probation department. Thank you. Who else, Mr. Simpson?
Thank you to Bailey for $3 in the swear jar and Barbara for $2 in the swear jar. By my count, though, I think 4 of the 5 have been used because Bailey swore twice and then swore a third time when putting his $3 into the jar, and then Barbara swore once when throwing in the 2. So of the $5, I believe 4 has been used. That's my count anyways. Back to Judge.
All right, Judge, I'm tendering a plea petition to the court by which Mr. Ross is going to be entering a plea to count 1, burglary, a plea of no contest to burglary, and count 1, a Class D felony, for which he will receive a sentence of 3 years TDOC, suspended to community corrections under the pre-2021 guidelines, on time served, concurrent to his Henry County sentence that he's currently serving. He'd be ordered to pay costs. He would have to pass drug screens as a condition of his community correction sentence with 0 tolerance for failed screens, and he would also be banned from Walmart. He would also enter a plea to count 2, shoplifting, a Class A misdemeanor, for which he would receive a sentence of 11 months and 29 days suspended to community corrections, concurrent to count 1, with credit for any time he served. He would be ordered to pay costs, be banned from Walmart, and he would owe restitution to Walmart in the amount of $163.73. He would be sentenced as a range 1 offender, and he would receive jail credits from July 3rd of this year until present.
All right, Mr. Ross, raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, nothing but the truth, so help you God.
State your full name for the record.
Darrell Eugene Ross.
Step up there to the podium.
Darrell Eugene Ross.
Ross, you're here today charged with 4 different counts in an indictment, but you heard your lawyer indicate what your agreement is to plead to 2 of those. I want to make sure that you understand what you're charged with. Have you seen or been shown a copy of those charges? Talked them over with Mr. Simpson. You and he discussed the range of punishment you're facing, as well as any possible defenses you might have.
Yes.
Well, it's indicated you want to enter a plea of no contest. You understand that means you understand what the state's evidence is. You're not going to admit you did anything, but you're not going to contest the state's evidence when they tell me what their evidence will be. And that evidence will be used to support a finding of guilt of your part. You understand that? You understand you have a right to plead not guilty and to have a speedy and public trial by jury.
Yes.
You understand you would have the right to have a lawyer at that trial and to have one appointed, as I've done with the public defender.
Yes.
You understand that at trial you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Mr. Simpson could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
You understand that's going to result in 2 convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You understand everything I've explained to you.
Yes.
You want to plead no contest and waive your right to a trial.
Yes.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will? You understand that I have to have facts presented to me that will allow me to find you guilty under those facts.
Yes.
And I want you to listen as the state comes to the podium and tells me what their evidence would be if this case went to trial. You'll step to one side, please.
Yes, Judge, if this case had gone to trial, the state would expect to be able to show that back on July 3rd of 2025, Officer Brad Simpson made contact with Mr. Ross at the Waverly Walmart. They had been monitoring him. They had observed him taking some things when he had passed off points of sale When he was there, they identified him and they found several items that he had taken. The value of that merchandise was $163.73. Also, Mr. Ross had previously pled guilty to shoplifting in another county, and he had been trespassed indefinitely from all Walmart locations at that point in time, which is why he was also charged with burglary. Those are the facts.
All right. Mr. Ross, you understand that's what the state's evidence would do?
Yes, sir.
You still wish to plead no contest to those facts?
Yes, sir.
Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Sensing's done a good job of representing you competently?
Yes.
Mr. Sensing, do you know of any reason he should not enter this plea?
I do not.
Then Darrell Eugene Ross, in docket number 15125, plea of no contest to count one. I find you guilty of burglary. Sentence you to 3 years Tennessee Department of Corrections as a rank one offender. And you are sentenced to suspended to community corrections under pre-2021 guidelines. This will be concurrent to your Henry County sentence. You must pay the court costs. Also, you must pass all drug screens with a zero tolerance, and you're banned from Walmart. Count two, you're found guilty, sentenced to 11 months and 29 days in the county jail. That will also be suspended to community corrections. Concurrent to count one, the credit for time served, you're ordered to pay the court costs, also banned from Walmart, and ordered to pay restitution to Walmart of $163.73. And count 3 and 4 dismissed as part of this agreement. Thank you. Anything you have another one?
Next matter, Judge, is State versus Michael Unger, who is in fact on page 10 of the court's docket. Case number 15126. Mr. Unger tendering a plea petition. I don't have a copy, so I'm going to do the best I can to remember. He's going to be entering a plea.
I'll read it. If you want me to, that'll take you off the hook.
Well, it's kind of, it's 6 years. He's going to be entering a plea to count 2 of no contest to possession of meth with intent to distribute, amended to attempt a Class C felony for which he received a sentence of 6 years TDOC, suspended on time served to supervised probation. He assessed a $750 fine plus costs. He would have to pass all drug screens with zero tolerance for failed screens, and he'd be ordered to complete the Jack Gene Center as a condition of his probation. The remaining counts would be dismissed in session.
John, raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the testimony you now give in this case should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am. State your full name for the record.
Michael Glenn Unger.
Mr. Unger, you've heard your lawyer go over what the agreement is on these charges, but you have a 5-count indictment. Have you seen or been shown a copy of all of those charges, talked them over with Mr. Sensing?
Yes, sir.
And you and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest. All that means is you understand the state's evidence. You're not going to admit you did anything, but you're not going to contest the state's evidence. And I will use that evidence to find you guilty according to this agreement. You understand that? You understand you have a right to plead not guilty and to have a speedy and public trial by jury in this court.
Yes, sir.
You understand that if you went to trial, you'd have the right to have a lawyer and have one appointed, as I've done with a public defender.
Yes, sir.
You understand that trial, you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and Mr. Simpson could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that at trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer looked at.
Yes, sir.
You understand that that's going to result in a conviction, and that felony conviction is going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you.
Yes, sir.
You want to plead no contest and waive your right to a trial and to an appeal.
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty.
Yes, sir.
And I want you to step to one side and let the state come to the podium and tell me what their facts would be if your case went to trial.
Yes, Judge, if this case had gone to trial, the state would expect to be able to show that back on June 11 of 2025, Deputy Aaron Davis with the Humphreys County Sheriff's Department made contact with Mr. Unger. He didn't use a turn signal, and so she stopped him, and she identified him. The tag to the vehicle came back registered to someone else. He was on probation out of Humphreys County, so she did a probation search. And during that search, she found about 7.5 grams of meth on his person. Those are the facts.
Mr. Unger, do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You believe that Mr. Simpson has done a good job of representing you confidently?
Yes, sir.
Mr. Simpson, do you know of any reason you should not enter this plea?
I do not.
To Michael G. Unger and docket number 15126 upon your plea of no contest to count 1, counts 2, 3, 4, and 5 are dismissed as a part of the agreement. I find you guilty, sentence you to 6 years Tennessee Department of Corrections that will be suspended on time served to supervised probation. You're given credit for time served and ordered to pay a $750 fine. The cost, you're to have no failed drug screens with 0 tolerance, and you must, as a condition of your probation, complete treatment at the Jack Jean Center. That means if you walk away or you get kicked out, that's going to violate your probation. You understand that? That's the judgment of the court that is talking to probation. Mr. Owen, you are standing up whenever I pause, so what's up?
All right, let's change things up a little bit. It's been a few days since we've been to Louisiana, so let's give that a go.
Okay, good morning. My name is Pete Freeman. I will be the acting chair today. To my right is Ms. Stapleton. To my left is Mr. Tillis. We will panel today. And we're here for the parole hearing on Robert Mead. Mr. Mead, would you state your name and DOC number for the record?
Could you speak a little louder, please?
Yeah, if not, turn the volume up. We can barely hear him.
Still, huh?
Yep.
Be red, I thought it was green.
If they know we're closer to them or something.
Try to
Now,
get.
Yeah.
did we hear him better?
Go ahead, state your name and DOC number.
My name is Mr. Robert. My name is Robert Charles Means Jr. And my DOC number is 395867.
Okay. All right. Okay, so we're at Dixon Correctional Institution with the staff at Dixon. Please introduce themselves.
Assistant Ward Ricky Williams.
Donald Cavalier, classification.
Okay.
Curtis Thurman, Mental Health. Xavier Source, Reentry.
Yes, sir.
Okay, thank y'all for having us today. All right, Mr. Mead, what I want you to do is I'm gonna read some information into the record. You tell me if it sounds correct. Mr. Mead, you are a first felony offender. You had a parole date of 8/1/21. You have a good time date of 2/24/46. You have a full term date of 2/19/2047. You're serving 50 years for the charge of attempted second-degree murder. Does that sound correct, sir?
That's correct.
Okay. Mr. Mead, what I want you to do, I want you to tell us what you did to get yourself put in prison and why do you think we should let you out today? Why should we consider letting you out? Okay? Go ahead.
Sir, on February 18th, 1997, my girlfriend, Miss Marquita Neely, she was at Leonard Sherbert Medical Center in Terrebonne Parish, home of Louisiana, with her son. Her son and my stepson, he was there for Jollies. He was there for 6 weeks. And while he was there, me and her, we broke up. she wanted to go on with her life. And I used to go to the hospital and sit up with him and visit him. She didn't want me to come there no more. So I went there that morning on February 18th, and I was ordered off the premises by security. I came back. I was in rage, my emotion got the best of me, and I went to the hospital, and I went there to shoot her. And I went to the room. She just had came back with her son from, I think he went and got an x-ray, Anthony Johnson Jr., my stepson went get an x-ray. And when I came in there, she just had got back and had a nurse in there, Miss Ruth Carlos. And she said, that's Mr. Meads that wrote the report on that. I don't want him visiting no more. I said, I'm here to see my son and you, my stepson, Anthony. And the lady said, Ms. Carlos said, Mr. Meads, you got to go. She don't want you here no more. So I said again that I was here to see them. And that's when I took the gun out and she told me to leave. Ms. Ruth Carlos went out the room and I started hitting Miss Marquita Nearly with the gun beside the head, 25 automatic. And she was screaming, saying, somebody please help me. And she tried to run out the room. And I went behind her and hit her with the gun again. The glove was back in the room and I tried to shoot her. And the gun jammed 3 times. And I pulled the trigger again and the gun went off several times and she was shot. And she ran out the room.
Okay. Why did you want to shoot her?
Because she wanted to go on her life, and I wasn't thinking about everybody, her feelings. Okay. This focus on me. I was self-centered, and I felt that I got rejected, and I wasn't thinking at the time. I was emotions get the best of me, and I was wrong for what I've done.
Any drugs, alcohol involved?
No, sir. I used to drink, but I social, but I didn't drink that day. I just let my anger get the best of me.
Good. Good. Okay, now tell us why you think we should let you out. What have you done in prison that you think that that we should consider letting you out?
Sir, I've been incarcerated 28 years and 8 months. Since I've been incarcerated, I have come to higher ground dealing with me knowing what I'm in here for. I'm very guilty of the charge, and I've accomplished so much since I've been in incarceration. I have gotten every course that can help me in the healing process. Anger management, substance abuse, living in balance, character counts, GED school, and I experienced growth over the years, mentally and spiritually growth. Because when I was incarcerated, I was a younger individual. I was immature. And through the years of being in incarceration, I came in contact with some people as individuals on a spiritual level that helped me become stronger in life and to help me advance in maturity. And God had come in my life, and that's how I changed. I'm not the same person I was years ago. Because I experienced growth in all areas of my life. And I take responsibility and I'm accountable for my actions. Marquita and Anthony didn't deserve what I did to them. I inflicted mentally and physically pain upon them. Attempt murder and aggravated battery upon them that I was convicted on. I'm very guilty of. And
have you taken victim awareness?
Ma'am, sir?
Have you taken victim classes?
Yes, sir. I took victim awareness. I took victim awareness. I wrote an accountability letter years ago, and it was sent to the district attorney's office and Sheriff Association, and they give a copy of the letter to her, and she received it.
Okay. Y'all been in contact with each other, I read.
But when my mother was living, my mother passed 7 months after I got denied last year, and we stayed in contact. With my mother, I used to call her, and Marquita and my family.
At PCI.
Okay, I heard him talk about mental health, and earlier I think your mental health person is there.
Yeah. Yes, he is.
Yes.
Can he tell me what his diagnosis is, and does he have to take any medicine?
I couldn't tell you that right offhand right now. I'd have to look that up to see that. I can tell you what programs he's completed.
Okay, tell me what mental health programs he completed.
Okay, he's completed Cage of Rage twice. He took Cage of Rage again in December 2024, completed Nurturing Parenting again. July of this year, Celebrate Recovery, Denial Management, Drug Dealers Anonymous, Substance Use Education, Going Home, Staying Home, and Living in Balance as well.
Is he on any medication?
I'm not sure, sir. I don't have that on me. No, sir.
On any medication, any mental health medication?
No, he don't meet that criteria.
Okay, thank you. Thank you. That's what we needed to know. Okay, your case has been, well, let me give, you have a speaker, Mr. Myers from the Parole Project.
Yes, good morning. Kerry Myers with Louisiana Parole Project. We want to let the board know that we've accepted Mr. Meads as a client. Based on everything you've just heard from the warden, from his programming, from the mental health director, his conduct, his programming, those are the reasons we have taken Mr. Meads, his maturity. He's been incarcerated for 28 years on this sentence, has done more than half. He has a long-term residence plan with his brother and opportunities for employment. So Parole Project believes that we can provide him with the transitional support necessary for him to be successful upon release. So we just, based on these things, the reasons we accepted him as a client, we'd ask this board to grant his parole today.
Okay, thank you. Okay, Mr. Meads, your case was assigned to Ms. Stapleton, so please answer any questions Ms. Stapleton asked.
Mr. Meads, I've heard about your different programs that you've been doing, and that's wonderful. And it's wonderful that you're in a situation where you can get those programs and that you're taking advantage of them. But let's go back to the day that all of this happened. And some of the things that could have happened that didn't happen. First of all, we never hear anything about the little 3-year-old that was in the hospital and had been very sick in the hospital, like you said, for a long time. So when you beat her and she got hit with, I've got that she got hit with 3 live rounds, and some of them had penetrated double parts of her body. The child was with her in her arms, and the child's nose was swollen and his teeth were loose. Doctor said there was possible internal bleeding in the nasal cavity of the child. The little boy, the child's not mentioned. So what do you think about the child? You did all this while she was holding her baby.
Yeah, I mentioned it to Mr. Spring that the aggravated battery, attempt second-degree murder and aggravated battery occurred at the same time, at the same occurrence. And I'll show you.
So the aggravated battery was not included in.
Yeah, but
they let it out.
Yes. It was, I say that it took place. I let the record reflect that. Ma'am, you said it took place and happened because when I hit Marquito with the gun, and that's how Anthony, my stepson, he got hit with the gun because when she picked him up, she tried to leave out there, out the room. And I was hitting her with the gun, and he got hit with the gun in the process of my wrongs and my action. Because I let my emotions get the best of me, and I'm guilty of that as well. It's attempt second-degree murder. Committed those crimes, and I know I was wrong for what took place. And I take accountability for my actions. I'm guilty of the charges, both of them. Attempt second-degree murder and aggravated battery. That what took place. That's the facts what took place in the case.
Well, let me ask you this. You've been arrested before all this happened between April of 96 and you've been arrested 6 times for violent behavior before this happened. And you said you were immature. You were 23 or 24 when this happened. That's not a 16 or a 15-year-old. That's immature. So, I mean.
I like to reflect that even though I was adult in age, 23 years old, I was messed up in the head. I wasn't thinking like a man was supposed to. Because my acts that I carried out, the wrongs, I wasn't thinking about other people, the cause and effects of what it was going to take place in people's life. I was, total disregard for my life, and I didn't see of other people's feelings, how they feel, what it cause and effects, that it be mentally and physical abuse that was inflicted. And also we can go to emotionally, spiritually. Marquita and Anthony, they say I was affected by these shit spiritually. Don't believe in God no more, or why God would let this shit happen to me. That affects people all type of ways, financially. And I know and I understand that, I acknowledge that it was a ripple effect on the whole community. I apologize to Terrebonne Parish, Tri-Parish area, Terrebonne, Lafourche, and St. Mary, that what I did was wrong. And I can only move on in life. The past, I got to move on in life. I just ask God to forgive me. I hope the victim forgives me. I got to move on in life from the past, but I cannot change that. But this is what took place, the facts. Everything what took place, the aggravated battery took murder, I'm guilty of.
Okay, so here's a statement in the police report, Terrebonne Parish Sheriff's Office. There were at least 10 people in the area during the incident. 3 were other patients, so they were juveniles because this was a pediatric unit. 3 were other patients in the area as well. There were oxygen units throughout the hospital that could have, what you did could have ignited a spark. As stated earlier, this occurred in a pediatrics floor. Tangipahoa Parish Sheriff's Office is requesting that this blatant disregard for life be taken into consideration when establishing a bond. So this was about a bond. They also have wishes for it to be taken into consideration the disregard for the health and the intent on the hospital. And you know yourself that you did your best to shoot that lady, that it didn't fire at first and you kept hitting the gun to try and make it fire. So it was a very deliberate act. It was a very egregious act, and it was a very vicious act. And it could have affected way more people than it did. And I hear you taking accountability for that, but also with all of this comes consequences. I mean, there were consequences for this child and for the lady, and I know she's forgiven you, but society was involved in this too. That place could have blown up, or when you started shooting, it could have randomly hit other people, which you've talked about. So everything you did was at that time, that really wasn't immaturity, that was rage. You just didn't care. And you're doing a lot to correct yourself, and maybe you have corrected yourself by now. But like I said, that there's consequences to that type of behavior, because there could have been much higher consequences that day that, thank the good Lord, weren't. I don't know anything about the child. You know, he's older now too. I really didn't hear further on what the surgery led to. I mean, if there was internal bleeding, but the baby was hurt in her arms, and you didn't care about that child, even though you just admitted he'd been in the hospital for 6 weeks already. So, what you did then was a deliberate act. It was vicious. You were sentenced with a plea bargain to 50 years. They dropped what happened to the little boy. That's not even part of it. It's attempted second-degree murder. So I'm glad you're doing all you're doing. but the past speaks for itself too.
Okay,
I'd like to call executive
so I
session.
want one, I'd like to ask him a question.
Okay.
Do you ever have any contact with that child?
What you say, this, compact, what you mean?
Have any contact or communication with the stepson?
No, ma'am, no, sir. Marquita, me and her been communicating last like
Right.
2013. I don't stay in contact with him, but his mother tell him that I asked about him, that he say that he prayed for me and he forgave me. He's 20, he's like 32 years old right now. And he said he forgave me, the victim, she said she forgave me. And I feel that's what the board should consider also, because the victim have a voice. Also, and I know I was wrong. I take accountability for my actions. And I was wrong for what I did. I know it was a ripple effect on everybody, not just the victim, the whole entire parish, tri-parish area, Terrebonne, Lafourche, and St. Mary. And the impact that everybody lives. Could be financially, emotionally, spiritually. And that took place with Marquita and that. Well,
Okay. Okay, I think we got what you're trying to say. Mr. Tillis, you call for an executive session?
Yes, yes.
Mr. Tillis has moved for an executive session. I'll second.
Freeman,
Yes.
Tillis.
Yes.
Staples. Yes.
Okay, we're gonna go into executive session to discuss confidential matters. We'll be back in a few minutes.
Okay, well, they go to executive session. Let's go to Judge West, and we'll come back once they're back.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hebert, in cause number 25 DCCR 0740, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements from February 11th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Because you do what they charge you.
Okay. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
The paperwork on the tablet, did y'all go over it? And do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
That's correct.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Hebert is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
All right, let's go back to Louisiana.
Yes.
Stapleton.
Yes.
Tillis.
Yes.
Okay, the parole board's ready to vote. Ms. Stapleton will be voting first since it was her case.
Mr. Meads, I'm happy for all of your efforts while you're in there, and that's wonderful, and you should consider that wonderful and continue on that path. But what happened was so very violent and so very deliberate, and you did get a plea bargain. And I'm glad, the lady has forgiven you. We didn't hear from the child. We don't know what his feelings really are. But sometimes, you know, there's consequence to society for bad actions like this. So my vote today is, to deny.
Mr. Tillis?
My vote is gonna be to grant to the, Louisiana Parole Project.
And my vote would also be to grant to the parole project. I think you are doing wonderful. I know you know it takes a unanimous board for you to be paroled today. Please don't put that head down, man. You'll be back soon, and you are doing what we asked. So, you know, good luck to you. Is all I say. Good luck to you, sir.
I like to record reflect also, that I wasn't offered no plea bargain. I went to trial.
Right.
Carried from 10 to 50. I was convicted and I received the maximum sentence. I never was offered no plea bargain.
Oh, I thought that was what
No, it was a
charges.
I'm incarcerated. I was convicted for attempted second-degree murder.
Okay, well then you went to trial and a jury or a judge.
That's good.
Okay,
Your vote's still the same?
it's still the same.
Okay, so her vote's still the same. So it's 2 out of 3 votes. So, today your parole's been denied. Good luck to you.
Excuse me.
Denied. So close. Oh well. They can't all be winners, I suppose, as they say. Judge Boyd, let's go there.
5CR007063, 2025 CR00.
Well, she reads the case. Kai, thank you so much for the $2 super sticker. Appreciate that very much.
07000, State versus Troy Xavier Trevino. Can I have parties announce?
Rick Pena for the state of Texas.
Travis Kettner for Mr. Trevino, Your Honor, we're ready.
And are you Mr. Trevino?
Yes, ma'am, I am.
Just one moment. Off the record for a moment. Deputy Lord, if you could move them down to the other end. All right, we're back on the record. And in each of these cause numbers, you entered a plea of no contest. And the cause number ending in 6-3, you entered a plea of no contest to count 3. The state waived counts 1 and counts 2. And 3-1 and 0-0, you entered a plea of no contest. Oh, and I'm so sorry. We also have 2025 CR 07003, where you entered a plea of no contest. Just one moment. Did you enter into a plea on 2025 CR 00631?
That's going to be TOC as part of this.
All right.
Yes, that's correct.
So then there's a correction. The defendant did not enter a plea in 2025 CR 00631. That is a case that will be taken in consideration. The defendant did enter a plea of no contest in 2025 CR 00703. Have both parties had a chance to review the PSI report in each of these cause numbers?
Yes, Your Honor.
Yes, Your Honor.
Any objections to the PSI?
No, Judge.
None from the state.
None from the fence.
All right. Does anyone have any witnesses?
We do, Judge.
The state does not have anyone. The state only has argument.
All right, defense, you may call your witness.
Judge, we're going to start with Maria Trevino.
Good morning. All right, just make sure you keep your voice up. It's so that the court reporter will be able to hear and so that I'll be able to hear as well. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. State your name for the record.
Maria Trevino.
All right, defense, you may proceed.
Thank you, Judge. Ms. Trevino, how do you know Troy?
Troy Trevino is my nephew.
And so how long have you known?
Always.
Have you, and of course, you're aware of why we're here today, correct?
Yes, sir.
And so you know the nature of the charges against them?
Yes, sir.
And it's certainly you know that two of them involve an aggravated assault with a deadly weapon.
Yes,
Were you surprised when you heard that Troy had been arrested?
yes, sir.
And why were you surprised?
Because that is not character of my nephew.
To your knowledge, had he ever been arrested before these incidents?
No, sir.
And you know that why we're here today, right?
Yes, sir.
So Judge Boyd is going to sentence him based on kind of the situation, all the different charges today, correct?
Yes, sir.
And if he were to receive probation, which is obviously what you want,
Yes, sir.
would you be, knowing about how probation works, be able to support him and assist him with probation?
Yes, sir. 100%.
Are you afraid of him?
No, sir. Not at all.
Are you worried about having him in your home?
No, sir. Not at all.
And so if you needed, you know, if he needed a ride to one of his classes, was that something you'd be willing to do?
Yes, sir.
Or borrow a little bit of money?
Yes, sir.
Some of these things cost money. And you understand that as part of this, he has acknowledged he has a drug addiction problem, is that right?
Yes.
And so do you use drugs?
No, sir.
And you maintain, do you live near him?
Yes, sir.
And is your home nice, clean, drug-free home?
Yes, sir.
And so knowing all this, you would like to ask the judge for probation, is that correct?
Probation. Yes, sir.
We'll pass it with you, Judge.
Dave?
Yes, ma'am. Good morning, Mr. Revere.
Good morning, sir.
Thank you for coming this morning. I have a few questions for you. You said that Troy is your nephew, correct?
Yes.
Okay. So, like you said, you've known him his whole life, right?
Yes.
Have you ever known of him to be violent?
No, sir.
Have you ever known of him to be violent towards women?
No, sir.
Did you know that he owns a gun?
No, sir.
So you never seen him with a gun before?
No.
You ever seen him in possession of any type of drugs?
No, sir.
Have you ever seen him under the influence of anything?
No, sir.
Okay. Have you ever seen him abuse alcohol before?
No, sir.
Ever appear drunk in front of you?
No.
How familiar are you with the facts of these cases that he's here for in court today?
My heart, right? You're saying facts.
Well, let me ask you this way. Has anyone talked to you about what happened on these 2 days between Troy and the victim? Okay, so you kind of have a little bit of an idea of what happened. Are you aware that he threatened her life?
Yes, sir.
Are you aware that he threatened to kill her whole family?
No, that I didn't.
Okay, are you aware that he used a gun on her?
No, sir.
Are you aware that he put that gun in her mouth and threatened to kill her?
No, sir.
Okay. Are you aware that he choked her?
No.
Are you aware that he choked her to the point where she almost passed out?
On that one, he had posted something on social media.
Okay, so you kind of had a little bit of idea about that?
Mhm.
Okay. And you are aware that both of these incidents only took place a few months from each other, correct?
No, sir.
Okay, so do you understand one of them happened in January and one of them happened in March of this year?
No, she didn't state when that happened. She put it on Facebook.
But you are aware that there are multiple instances of violence by Troy towards the victim, correct?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
We have no further questions for this witness.
All right. Any objections to the court asking a question?
None from the state.
No, Judge, thank you.
All right. Have you had any contact with the complainant?
Excuse me?
Have you had any contact with the complainant?
I think she might.
The victim.
No,
Outside. And does your nephew have any children?
no, ma'am.
Okay. All right. Thank you so much. Any other questions?
Judge, we
I'm
got-
sorry, any other
we got
witnesses?
just a couple.
Oh, no problem. Call your next witness.
And intervene.
Hello.
Good morning, ma'am.
Good morning. All right, could you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
My name is Landon Flores.
All right, defense, you may proceed.
Landon, how long have you known Troy Tremaine?
I've known Troy almost my whole life.
And how is he related?
Oh, hold on one second. He needs to speak or speak. Troy's my cousin.
And you're aware why we're here today, correct?
Yes, sir.
And you're aware of the charges that Troy has pleaded guilty to, correct?
Yes, sir.
And of course, you know that they are very serious, including aggravated assault
Yes, sir.
and what they would call family violence choking.
Yes, yes, sir.
Brought up by the prosecutor with the last witness. Knowing this, are you afraid of Troy?
No, sir.
And prior to him being in jail, did you all spend a lot of time together?
Yes, sir.
And it's you all about the same age?
Yes, sir.
Prior to these problems, have you ever known Troy to be in trouble?
No, sir.
Did you go to high school with him?
For a couple of years.
And during that time, was he a good student?
Yes, sir. He would attend all his classes and he was mostly focused on baseball.
And in fact, he lettered in baseball, is that right?
Yes, sir.
And he graduated from Lanier High School, is that correct?
Yes, sir.
Now, part of why we're here is we're asking the judge to place Troy on probation. You're aware of that.
Yes, sir.
If he was placed on probation, you feel like you could be supportive of his time on probation?
For sure.
So one of the questions we asked Maria earlier was, if he needed to ride somewhere to go to a class, is that something he's willing to do?
Yes, sir.
And he doesn't live with you, right?
No, sir.
But he doesn't live near you.
Yes, sir.
And so you're asking the judge very respectfully to place him on probation.
Yes, sir.
Have some witness.
State any questions?
Yes, Your Honor. Good morning. You said your name was Landon?
Yes.
Okay. My apologies. I just missed
No,
your
you're
first name.
good.
And you're Troy's cousin?
Yes.
Like first cousin?
Yes.
Okay. So you've known him his whole life?
Yes.
You guys ever hung out together?
Yes.
How often?
Saw it a few times. We've been fishing, had a sleepover when growing up. Me, him, my brother.
Okay. So sleepovers and fishing. So you guys grew up together?
Yes, sir.
Did a lot of activities together?
Yes, sir.
And you said you went to high school with him for a little bit? And you said he played baseball, right?
Yes.
Did you play baseball as well?
Yes.
So you guys were on the team together?
No, for high school, no. I stopped playing baseball, but growing up, yes, we played baseball together, baseball and football.
Gotcha. Okay. So just growing up like out home fun, you guys had playing football and baseball together, right?
Yes, sir.
All right. I see what you're. Are you familiar at all with the facts of what happened in these two cases?
Kind of, not really, because when I found out everything happened, there's like, oh, it's like, in general.
Okay, let me ask you this. Did you ever know about Troy being in a relationship with the victim?
Yes, I knew her.
Have you ever met her before?
Yes.
Have you ever known Troy to be a violent person?
No, sir.
Was there violent towards you at all?
No.
Other than maybe normal childhood roughhousing stuff?
No, sir.
You ever seen Troy use drugs?
No, sir.
You ever seen him use alcohol?
No,
So you guys never drank together or anything like
no,
that?
sir. I don't do none of that stuff myself.
That's good. I'm glad. Thank you. So would it surprise you then, like I asked, your aunt, I guess, is she your mom or your aunt?
That's my mother.
That's your mother. My apologies.
No, you're good.
Would it surprise you, like I asked your mother, if there are facts alluding to the Troy putting a gun in the victim's mouth
Yes.
and threatening to kill her?
Yes.
Threatening to kill her whole family?
Yes.
That would surprise you?
Yes.
Okay. Would it surprise you that he choked her?
Yes, sir.
Almost to the point of her losing consciousness?
Yes, sir.
But other than that, you've never seen Troy be angry before?
No, sir.
All right, I'll pass the witness round.
We have no further questions for this one.
All right, thank you so much for coming down.
Our next witness, Your Honor, is Maria Farias.
Maria Farias.
Angie, excuse me.
All right, sorry, Angie Farias. And
All right, we're obviously not going to leave this in the middle, so we'll be going into overtime. And remind me in the pre-show tomorrow morning, I just snapped a great picture of Ellie, quote unquote, trying to solve our ISP issues. So you want to be sure to check that out in the pre-show.
truth and nothing but the truth, so help you God.
I do.
All right, you can lower your hand if you'll state your name for the record.
Yes, my name is Angie Farias.
Thank you so much for speaking up. All right, defense.
Yes. Ms. Farias, how do you know Troy?
Troy is my godson,
And he's also your nephew,
and
correct?
he is also my nephew, yes.
How long have you known him?
Oh, like,
And during that time, have you ever known him to be in trouble?
no,
At the time that all this happened, were you aware that he was working?
yes.
You know where he was working?
I want to say it was some company that dealt with like construction and demolition.
To the best of your knowledge, was that a full-time job?
Yes, very full time.
Now, you're aware of the reason we're here today, correct?
Yes, I am.
And you know that we're gonna be asking the judge to place Troy on probation, is that right?
Yes,
Now, if he's placed on probation, he's gonna have rules that he needs to follow, things he can do, things he cannot do. You're aware of that?
yes, I am.
Are you willing to assist him in meeting his responsibilities of probation?
Most definitely.
So for instance, if we thought before, if he needed a ride someplace,
Yes, I would be willing to provide transportation.
if he needed a little bit of money, they have, different fees and services and things he would need to pay for.
I too would also be willing to assist with that.
Do you live near him?
I do.
Are you afraid of Troy?
No,
Now you're aware of the charges that he's pled to, which he has pled guilty.
yes,
And so you know they are very serious,
yes,
and you know they involve violence.
yes, I do.
But even knowing that, you're not worried about being around him or anything.
Not at all.
We're absolutely.
Good morning, ma'am.
Hi, good morning.
Ms. Farias.
Yes.
Troy is your nephew?
My godson, my nephew, yes.
My nephew Godson. Okay, so you've been involved with him his whole life then, right?
Whole life.
Okay. How was he growing up?
How was he? How was he?
How was he growing up? Yes, towards you, towards the family, things like that.
Very loving, respectful, active, fun, playful.
Ever show any anger towards you or the family?
No, never.
Ever seen him act out before?
No,
Did he ever have any trouble in school?
never.
Okay. So do you know how it came about that he became in ownership of a gun?
No,
Okay, so you never knew he had a gun?
I did not.
Okay, did you ever know of him to have a drug problem?
No,
Okay, so that surprises you that he does
Yes.
use drugs
very surprised.
and alcohol as well? Okay. Are you familiar with all of the facts of what happened?
Yes,
Okay. So you are aware that he put a gun in the victim's mouth?
I didn't have all the specific details, but I did know that he was put in jail. After speaking with my brother and my sister-in-law, they did briefly give me some of the information of what occurred, but I did not know about the,
Were you at least aware that he was in a relationship with her?
yes,
Did you ever meet her before?
yes,
Did you ever see them together?
yes.
Did you ever see any signs that caused you any concern for you between the two of them?
My personal opinion,
Yes, please.
yes, even at family functions, I mean, they got along well in front. And maybe just something from not having given I'm thinking of Thanksgiving, not giving the right beverage where it was like, oh, I didn't want that. And maybe just kind of, she did not get upset to like where she made a huge tantrum, but she just easily became bothered by the fact that, for example, oh, I told you I wanted a big ride, but you gave me sweet tea, and I was like, okay, because I love him so much, I'm like, this is just me speaking, but that's not very healthy for this,
Okay, so you saw issues of concern from her behavior.
Yeah,
Did you ever see any issues of concern from his behavior towards her?
no,
Did you ever talk to Troy about your concerns about their relationship between him and her?
just very little, like, hey, puppy, just, I don't like that she got upset. I know, I know. Is it all the time? No, I'm like, okay, well, maybe it's just something that I saw or at the moment type of thing. Maybe she had a bad morning, but yeah, concerns from him.
Okay. That's the witness.
No further questions.
All right, thank you so much for coming down.
Michael, thank you for gifting the membership. Appreciate it.
Next witness.
No training, please.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Joe Trevino.
All right, defense, you may proceed.
Good morning, Joe.
Good morning.
How do you know Troy?
He's my son.
And so obviously you've known him his whole life.
Yes.
Prior to this, had Troy ever been in trouble?
No.
How was he as a student?
He was a great student.
And did he graduate from high school?
Yes, he did.
And from where did he graduate?
He graduated from Rainier High School
And when was that?
in 2023.
And he was an athlete there?
Yes.
Did he play on the varsity baseball team?
Yes, he did.
Did he play any other sports?
He just played baseball all his life. That's all he ever did.
When he graduated, what did he do?
He was supposed to go to college. He got 2 baseball scholarships to go play, but he decided not to go.
Did he go to work?
Yes, he did.
And where was he working?
At American Abatement, Demolition and Construction.
And very briefly, what type of job is that?
They would go demolition, old buildings, and that's what he would do.
How much money did he make working?
I want to say it was $20 an hour.
Was there a lot of overtime as well?
There was some overtime when it was open.
Did he have a job title there? Was he a supervisor or anything?
Yeah, I think he was an assistant.
Now, you're aware obviously of why we're here.
Yes, sir.
So, prior to these incidents, right, had Troy ever been arrested?
No.
Not as a juvenile?
No.
And to the best, and obviously, this isn't a PSI, but he's not a gang member or
Oh,
anything.
no, he's not.
Were you surprised when he got arrested?
Yes.
Why were you surprised?
I didn't think he would ever get in trouble like that.
And you're obviously very familiar with the charges.
Yes, I am.
And so you know there's an aggravated assault, which is a very serious
Yes.
charge, as well as probably the next most serious charge is the choking.
Yeah.
Had you ever seen Troy be violent with anybody prior to this incident?
No.
Now, one of the things that has come to light through this process is Troy's struggle with drug addiction. Prior to these incidents, did you know that he was a drug user?
No, I did not.
And you know, one of the things, the main reason why we're here, obviously, we're gonna ask the judge to place him on probation, right?
Yes.
Part of probation, there's gonna be certain things that he can do, certain things that he cannot do. If he was placed on probation, would he be living with you?
Yes.
And prior to this, he was also living with you,
Yes.
right? So you understand that, kind of as part of his probation, right? Are you able to foster a home where he
Oh,
can be
yes.
successful?
Yes.
So you don't use drugs?
No, I don't.
Wife, obviously, she doesn't
No.
use drugs. Tell me the story like that.
I would have he's 20.
So, do you feel like, he can be successful?
Oh, yeah, he has his whole life to live ahead of him.
Judge will pass away.
You may proceed.
Thank you. Good morning, sir.
Good morning.
Troy's your son, right?
Yes, sir.
You love your son, right?
Yes, of course.
You don't want to see him get in trouble,
No.
right?
I don't ever want to see any of my kids get in trouble.
Understood. Neither would any father,
Yeah.
right? How was Troy growing up? Did he get in trouble at all?
No, he didn't. He was all about sports.
Did you ever have to discipline him at any point in time when he was a child?
No.
Okay. Did you know that he owned a gun?
No, I did not.
Do you know how he got the gun?
No, I do not.
Okay. You are aware of these charges, correct?
Yes.
When people commit crime, do you think they should face proper punishment?
Yes.
Okay. So regardless of prison or probation, you think Troy should face some type of acceptable punishment?
I think he's already been facing acceptable punishment.
Okay. So you don't think anything further should be done with this?
Probation.
Okay. Pass the witness, Your Honor.
Go for the questions.
All right, thank you. Call your next witness.
Amy Drago?
Would you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record. All right. Defense, you may proceed.
Hi, it's Amy. How do you know Troy?
He's my world and my son.
I'm sorry, I did.
He's my world and my son.
And so you know why we're here today, correct?
I do.
Prior to, these incidents, had Troy ever been in trouble?
Also,
And what type of a student was
he was a good student. He was straight A for the most part. He was athletic. He played sports. He was never a trouble child or never. He was never.
And were you surprised when you got arrested? Prior to this incident, how long had he been involved with the?
With Ileana, I would say maybe a year to 2 years. Did I approve? No.
Is she about the same age as him? Now you say you did not approve of her. Why did you not approve of her?
There was a lot of manipulation in their relationship, mainly on her part. But as a mother, I'm going to support my child, and if that is who he chooses in his life, I'm going to support both parties.
Part of this process, we've talked about this, is if he's on probation, he can have no more contact with this young lady, period. And in this particular instance, because of the circumstances and the way they came down, she is the victim of these crimes.
I understand. Do I agree?
And I understand that as well, right? Now, if Troy is placed on probation, would he be able to live with you?
Oh, that's where he stays, other than when he was staying there with her off and on.
Are you worried about having Troy in your house?
No, never. It's my child.
And he's never been violent with you?
No, never.
And to the best of your knowledge, you've never been violent with any of his relatives, friends, cousins?
That's not his name, and that's not his age.
Now, you've heard, we've talked about this before, obviously, but you've also heard some of the substance of these charges.
Sure.
The most serious is aggravated assault with a deadly weapon. There's also the choking charge.
Which I hear now.
And knowing about that, even knowing about those charges, are you worried about having Troy in your house?
No.
Now, if he's placed on probation, there's going to be certain things that he's required to do, certain things he cannot do. You're aware of that. Are you willing to provide him with transportation if necessary to attend classes, things like that? Are you able to, if necessary, loan him money?
Yeah.
To pay for, court requirements, court fees, things like that? If he, now, prior to this, he was employed, is that right?
Yes.
And where was that?
It was a demolition company, something in Middleton. My head is everywhere at the moment, but
I understand, but he was employed full time.
yes, full time, and he was his certifications, everything. He was ready to be a lead or a foreman.
How much did he earn?
About $20-something an hour.
So it's a full time job. It's a real job.
A real job,
And
not
with good money and all that.
very good benefits.
And so, and he's got certifications, so even if he did not go back there, he could go someplace else in short order and get a
Not
similar
far
type
from the
job. Would he ever need trouble as a juvenile cases or anything?
or we didn't allow that opportunity. We set them in sports, very active.
Judge will pass things.
Any questions?
It's okay. Good morning, Mr. Mino. Thank you for coming this morning, and thank you for showing support for your son. You testified that you'd be comfortable with him returning to the home. Who lives in the home currently?
Mom, dad, sister, and brother.
Sister, brother. How old is his sister?
Sister is 16.
And how old is his brother?
Brother,
I'm sorry, 7?
7.
7 years, okay. You're aware of these charges, correct? And had you met the victim before?
Oh, yes.
She used to live with you? How long did she live with you guys?
Excuse me, just a second off the record. You in the Gap shirt? What did the deputy say about talking to inmates? Are you on the docket? Are you on the docket today?
He's on the docket, Judge. He came in late.
Who are you talking to? All right, so everyone, you can't talk across the courtroom. You can't talk across the gallery. That's an issue. It has to do with safety with the deputies. Does everyone understand? All right, sorry about that. We're back on the record. You may continue.
Thank you. And you said that she lived with you for a year?
Yeah.
How was she in your home?
I mean, when Ileana first came into our home, I was at her home. Things shifted. When attitudes started to come about and, simple things became a bother. I didn't like the disagreements, so I asked her to leave because between my husband and I, we don't make our issues known to our children. It's done private, not like, So I asked her, if you cannot get along here, then you cannot leave her. And she had her own place and I asked her to go out because I don't condone that.
Where did she stay in your home? Did she stay His room? Okay, so they stayed in the room together? Okay. Did you ever hear of any commotion going on in the room when the two of them were there?
More so bickering and like, louder, that's when mom and because again, you don't condone that, and you guys not, you're not contributing to our house, you're not paying the bills, you don't have to pay in our house, and you don't see how you know it's in the house.
Understood. How often would you see Troy and Ileana bicker?
Not quite often, but if we did, it was, we made it to a point to share things.
Did you ever see Troy be aggressive with her in your home?
As far as physical,
Did you ever see him verbally abuse her?
amazing.
Both to each other? Okay. Were you aware that Troy owned a gun?
Yeah.
Do you know how he got that gun?
Not the gun. So, I don't know.
Were you aware that he was abusing drugs?
No.
You aware that he was abusing alcohol?
No.
Fascinating, Sharon. No further questions.
All right, any objections to the court asking a few questions?
None from the state.
No.
All right, so how old was your son when you allowed his girlfriend to move in?
She came in shortly after high school, so he was 18, going on 19, he's now 20.
And how old was she?
She's about the same age.
All right, so here's my question for you. Why would you allow an 18-year-old to come live in your house with your son?
So my answer to that is, Ileana has always given me the story that her parents have never been there for her. So being that she liked our environment, that we were very family oriented, she felt comfortable at our.
But you're letting them stay in a room together? So you know what goes on with them staying in a room together? So you allowed that in your house with your children there? Now, my other question is, are you aware that he had 2 cases against him where she's the complainant, January 24th, 2025? Are you aware that on that date, he was charged with aggravated assault with a deadly weapon?
No.
Were you aware about the impeding the breath, basically strangulation on that same date?
No, ma'am.
All right, so I'm assuming he was arrested on those days.
Yes, and not at my home, it was at her.
Okay, so he's arrested at her house.
On those days?
Yes.
No, the only arrest that I know that he was placed on was in March.
All right, so you're not aware that he was ever arrested for the January 24th, 2025. So when he gets arrested on March 14th, 2025 for the continuous violence, is that when you allow him back in your home?
I will allow him in my home anytime.
No. My question is,
He didn't come home.
He didn't come home.
No, that day that incident happened, he was at Ileana's house.
all right, and did you ever talk to him about what happened?
No.
All right, so where do you think, because I'm listening to your testimony, to your husband's testimony, and to the other person's testimony, where did he learn that in order to solve issues, you become violent with your partner?
I don't know, to be honest, and I would love to know that as a parent, as a mother, for someone who doesn't condone that behavior, I don't know. So those are all questions I still have for my child when he comes in.
Okay. All right, thank you so much. All right, any other witnesses? All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Troy Xavier Trevino.
All right, you may proceed.
Thank you. Troy, how long have you been in jail?
I've been incarcerated approximately 7 months.
So that would be since March.
Yes, sir.
Prior to going to jail, how were you employed?
I was working for American Pavement Demolition. I was a crew lead. I basically ran my own crew while the foreman and the supervisor went over blueprints. I actually got to get hands-on with the blueprints and safety action plans. Basically going over like how a job site's gonna get completed, basically like discussing how many men do we think we'll need to complete that job? What proper tools we'll need, what proper safety gear will be needed. Basically everything that'll be needed for the job and just make sure the job gets executed within that time frame.
I'm holding here a big stack of cards. Do you recognize these?
Yes, sir. Those are all my work certifications.
And there's approximately 18 cards, is that right?
Yes, sir.
And those are all I would say, advanced certifications that you, classes and things like that that you completed at your job?
Aerial lift, confined space, asbestos, lead handling, heavy machinery, aerial, basically.
Now, and approximately how much money did you make working for these guys?
So I was making about 21 to 22 an hour.
And there was overtime as well?
Yes, sir. When the jobs required overtime, it was over.
Now, since you've been in jail, so for the past 7 months, have you taken any classes in the jail?
Yes, sir, I have. I've completed a parenting plus class. I'm currently enrolled in a faith-based 12-step recovery class through Chrysalis Ministry Group. We're currently on step 4. I just went this past Wednesday. They also offer a outpatient program through their ministry group. So if I were to get released, I'd pick up right where I left off in the jail.
And you've also taken some of the,
I took a
let me ask you, you've also taken some of the BIP class, right?
yes, sir, which is a battery intervention prevention program class. I've completed 10 hours of that.
So you received a certificate, correct?
Yes, sir.
Now, as far as this Chrysalis program, is that one that they do provide outside of the Bear County Jail?
Yes, sir. They offer trade school classes. They help you get back into the workforce. They offer anger management, therapy, and my main one is a 12-step recovery.
And so is it fair to say that you are an addict?
Yes, sir.
And
Which I've acknowledged that, and I've made the initiative on my own while I was incarcerated to address all my personal issues and get myself back on track, so I can show that I'm a successful member of society and that it was a mistake. That I've learned my lesson and that I feel I deserve a second chance to get back out there in the world and prove that I've learned that it was a mistake and that I can be a productive, safe member of society.
now, you know the reason we're here today, correct?
Yes, sir.
And you know, obviously, we're gonna be asking the judge to place you on probation, is that right?
Yes, sir.
Now, as part of that probation, you and I have reviewed the PSI. One of the recommendation is not the correct word, but the statement from probation is that if you're placed on probation, they would ask that the judge send you to SATF. Are you aware of what SATF is?
Yes, sir.
So it's inpatient treatment, right?
Yes, sir.
Now, because you have come so far while you have been in jail, what we're gonna be asking the judge to do is to place you on what they call IOP, which is intensive outpatient treatment. You're aware of that?
Yes, sir.
Based on the classes that you've taken and the time that you've had to reflect on this, do you feel that you would be successful with intensive outpatient treatment?
100%, sir.
And also, as part of probation, we have also talked about this, you are not to have any contact with this lady anymore
That is what I say, and I'm 100% okay with that, sir.
for the rest of your life.
Okay, that's fine.
You don't have any children with her,
No, sir.
so there's no reason for you to have anything to do with her.
Yes, sir.
Now, you're familiar with your charges, obviously, right?
Yes, sir.
And the most serious of those is an aggravated assault with a deadly weapon.
Yes, sir.
Did you commit that crime?
Yes, sir.
Where did you get the gun?
Unauthorized use.
Somebody from the neighborhood?
Yes. If there's something like that.
And, at the time that you had that gun, were you using drugs?
I was, yes, sir, occasionally.
And, drinking?
Occasionally, but it wasn't an everyday thing. Yes, sir.
When did your drug addiction, alcohol addiction, when did it get really severe?
It's not that it got bad, it's just that buttons were pushed that made it seem like it was bad when it really wasn't.
I'm sorry, could you repeat that? I didn't hear.
It's not that, I guess you could say no matter any chemical abuse, any abuse of alcohol is considered an addiction. So yes, you could say it was an addiction, but it's not that it was a bad addiction, because even though all drug addictions are bad addictions, it's just that buttons were pushed, certain areas like manipulation and all that were pushed to cause reactions that made it seem like they were bad outbreaks.
Now, this was,
I'm so sorry to interrupt. When you say buttons were pushed, what do you mean?
Like verbal manipulation, like basically like being told that I wasn't good enough or that, like basically like just a bunch of stuff like to get me down in my head or.
Okay.
Yes, ma'am.
now, would you say that in your relationship with Eliana, that, you could have done, needless to say, you could have done things a lot different?
Yes, sir. I could have just walked away the first time we got into an argument, but I didn't. These past 7 months that I've been incarcerated, I've had a lot of time to reflect that God gave me many chances to leave and walk out that door. And many people told me, even my mom and my dad told me, like, hey, they're right, this is where I was gonna end up if I stayed in the relationship. And I still didn't listen, I decided to stay and look where it got me. I spent 7 months in Bear County Jail.
And you know that no matter what she did, this is your responsibility.
Yes, sir. And I take full responsibility, I understand that, and I take full responsibility.
And so no matter what buttons were pressed or anything like that, none of that justifies any other
Yeah,
problem.
no, it doesn't.
That's the way.
Morning, Mr. Trevino.
Morning, sir.
You testified that you got the gun illegally,
Yes, sir.
and who did you get that gun from?
Somebody from the neighborhood.
Someone from the neighborhood, okay. You paid cash for it?
Yes, sir.
Okay. What would you say your drug of choice is?
My drug of choice was marijuana.
Marijuana?
But it wasn't really a drug of choice. It just helped with like the backache, helped me go to sleep because I'm working long hours up first thing in the morning.
Okay, you used other drugs too, didn't you?
Cocaine.
Okay, all right.
But that was once in a while. It wasn't a daily thing or nothing like that.
Okay, so you use marijuana more than cocaine?
Yes, sir.
Okay. I'd like to talk to you about this incident from January 24, 2025. So at that time, you were in a relationship with Eliana Contreras, right?
Yes, sir.
Okay. How long had you guys been dating up to that point in time?
We had been together over a year. We've been together since May 17th of 2023. I looked
Okay,
before then.
so almost 2 years.
Yes, sir.
All right.
Almost 2 years.
Almost 2 years, and you guys were living together, right?
Yes, sir. I was back and forth between her place and my parents' place.
Okay. Which address is hers? Is hers 225 East Sherrill Drive?
Yes, sir.
All right. Excuse me. All right, so you were at her place on that day, right?
Yes, sir.
All right. And probably wasn't a perfect relationship between you and Eliana, right?
No, sir.
You guys had your ups and downs, right?
Sir.
In fact, this day you guys got into an argument, right?
Yes, sir.
And she had broken up with you?
It was the other way around.
You had broken up with her?
Yes, sir.
Okay, that made you angry though, right?
Not really. It's just the fact that I tried to leave and she didn't really let me leave.
She didn't let you leave. Okay, so she never ran and locked herself into the bathroom on
She
that day?
did, but she had my truck keys.
Okay, so
She
she
had-
did and she took your truck keys.
Yeah, she
Okay,
had the phone and the keys.
all right. You ever made threats to kill her?
Maybe. I do not remember correctly.
Okay, so when she was in the bathroom, you do not remember saying, open the fucking door now or I'm going to start shooting?
No,
You don't remember saying that?
no, sir. Like I said,
All right.
I might have. I'm not gonna say I didn't, but
Okay, all right. You also remember putting a knife under the door, right?
no, sir.
You never did that.
I don't remember.
Okay.
I'm not saying I didn't do it, but I'm saying I don't remember.
You don't remember, so you might have done it.
Yes, sir.
All right. And you slid the gun under the door the whole time, right, while she's in there?
How can I say this? How is a 3-inch barrel 30 point gonna fit under a 1-inch crack?
Well, I mean, you tell me, because it says here that's what you did.
I didn't do that.
You didn't do that.
No, sir.
In fact, you broke into the bathroom, right?
I hit the door and the top half broke. After that, I left it at that.
You looked at that, so you didn't pull her out of the bathroom?
No.
You never threw her on the bed?
No,
Okay. You never covered her mouth while she was on the bed?
no, sir.
Okay. And that was at that point you tried to leave, right?
Sir,
And you made any threats with her when you were leaving?
I might have just, sir.
So you might have said you better watch your back because I'm coming back to kill you?
Okay, no, I didn't say that.
You didn't say that. All right. So you left and you came back later on, right?
I believe so.
And the house was locked, right? You couldn't get in?
No,
You can get in, okay. And you tried to break in through the bathroom window, right?
no, sir.
You didn't try to do that, okay.
No.
But you did get into the home, didn't you?
She eventually let me in and we talked.
She let you in, she didn't force you in?
No,
All right. And you pushed her on the bed, right? Because you guys got into another argument a second time?
yes, sir.
Okay, so you pushed her on the bed and you began to put your hands around her neck, right?
I do not remember.
You don't remember, okay. And you don't remember her coughing to the point where she felt like she was choking?
No, sir.
Okay, you don't remember that either, okay? And at that point is when you left the second time, right?
Yes, sir.
All right. I want to talk to you next about the incident that occurred 2 months later.
With the day I got arrested.
Then you got arrested in March, yes. I want to talk to you about that. That also was at her place, right?
Yes, sir.
All right. And you guys got into another argument that day, right?
Yes, sir, in the morning.
In the morning.
She went through my phone and she found
Yes.
some stuff she didn't like.
Yes, exactly. She found that you were texting other girls, right?
Yes, sir.
All right, and that made you upset, right?
That she went through my phone because my phone was dead. So she went out of her way
Mhm.
to charge it. And at that, my phone has a Face ID. So she went out of her way to charge it
Mhm.
while I'm asleep and get my Face ID to
And
go through my phone
go
without
through your
permission.
phone. Right, exactly. She didn't have your permission,
No, sir.
so that upset you.
Yes,
that
sir.
She went through your phone without your permission. Okay. So you got into the argument about that. And
Yes, sir.
it was at this point that you got angry and you started to assault her again, right?
I moved her out the way and I packed my stuff and I left.
You moved her out the way, so
I packed
you
my
shoved
stuff.
her?
Yes.
You
Yes,
pinned
sir,
her
I
down
did.
on the ground?
I didn't pin it on the ground, but I wouldn't mind. I shoved her out of my way so I can grab my stuff. I loaded it into my truck and I left.
Okay.
But did she put in the statement where
Hold
she
on.
was calling me from?
Hold on. I'm asking you questions here. Just hang on a second, all right?
Yes, sir.
All right. So when you're packing up your things, that includes your gun, right?
No, sir. I didn't have a firearm on me.
You didn't have a firearm on you.
And they didn't
How would
monitor-
how would you carry your gun when you did have it on you?
It stayed in the truck.
Stay in the truck, so you never had it on your person?
No, sir.
Ever?
No, sir.
So at no point in time you pinned her on the bed again?
No, sir.
At never point in time you put your hands over her mouth?
No, sir.
You never told her you're gonna kill her?
No, sir.
You never put that gun in her mouth, right?
No, sir.
Okay. You never pointed it at her head?
No, sir.
And you never threatened her several times, not only you're gonna kill her, you're gonna kill her family.
No, sir.
You never said anything like
No,
that?
sir. I got along actually really well with her family, especially her little sister.
I'm glad. I'm glad you did. You ever hit her with that gun?
No, sir, I haven't.
Never.
Never.
All right. You ever showed Eliana the gun?
She had seen it, yes.
She'd seen it
She knew it was in the truck.
in the truck. You ever brought it in the home?
No, sir.
All right. So she only saw it in the truck?
Yes, sir. It stayed in the truck.
Stayed in the truck the whole time. All right. So that was the first time, right? Then you got into an argument the next day, right?
When the day I got arrested?
Correct.
I
That
got
morning,
That morning,
you got into an argument.
we only
with her?
got in an argument that morning.
Yeah. Okay. So there was never multiple arguments?
That day,
Just-
no, it was just that morning.
Just that morning, just the one. All right. And that was again because she went through your phone a second time, right?
No, that was when she went through my phone.
You went through your phone the first time. Okay. So there was never multiple times that she went through your phone?
No.
Okay.
Maybe the other time that we argued, maybe those first ones, but that one, the day I got arrested was just that morning.
Just that morning. Okay. And that made you angry, right? Again.
So like I said, I packed my stuff into my
Packed
truck.
your
and
stuff and you tried to leave. Okay.
And that's when she contacted me through, I blocked her number because that's when we agreed we were done. And that's when she was contacting me through fake numbers and all that.
So she was reaching out to you.
Yes.
Okay. So you never put her on the bed and choked her a second time?
No, sir.
You never hit her in the face with the gun?
No, sir.
Never put your forearm into her neck?
No, sir.
You never tried to choke her by doing that?
No, sir.
You never told her my face is gonna be the last face you're gonna see?
No, sir.
Okay. And again, the second time around, you never threatened to kill her and her family, right?
No, sir. Like I said, I got along real well with her family.
I'm glad you did. I am glad. Okay. I'll pass the witness, Your Honor.
No further questions.
I have a couple of questions. Any objection?
None from the state.
None, Judge.
Why did you do this?
I was, my buttons were pushing. I guess I just reacted. I didn't know I ever could react that way. I've
All
never.
right, so your buttons were pushed on January 24th, 2025?
Yes, ma'am.
All right, what buttons were pushed?
Basically verbal abuse, manipulation, and
And when you say manipulation, what do you mean by that?
basically like making it seem like I was the reason when we were arguing when it wasn't me. Or like that I was the root of all of our problems when it wasn't really. Just
All right, did your parents kick you out of their home?
No, ma'am.
Why didn't you just go back to your parents' house?
Like I said, I should have listened and
Well, no, not I should have. Why didn't you?
guess she did. Said because I loved her and I thought we could work it out. As many times we've discussed it, we tried, and like I said, in the 7 months I've been here, I've seen that they were right. Everyone was right, even my boss.
I mean, don't everybody always see that
But,
people were right once they're at the jail? So why did you go back on March 14th?
we were on good terms then, and that's when she had went through my phone, and that's when she had seen messages with another girl.
So why didn't you just leave?
I did leave, and that's when she contacted me through.
Well, no, because there's a continuous violence here. So you have an assault, choking. They say impeding breath, but it's choking. Then you have an aggravated assault with a deadly weapon. That's with a weapon. So all that happened on January 24th, 2025. And then you go back on March 14th, 2025, and that's where the continuous violence comes in.
Yes, because I admit I shoved her out of the way when I left. I loaded everything in my truck and I left, loaded all my stuff. Then when I was about maybe 5-10 minutes away, she was still blowing up my phone through private numbers. I kept blocking them because, like I said, I had a number blocked. And so I ended up going back because she was there telling me to come back. So me being dumb, I went back. And once I pulled into the property, SAPD was right there.
All right. Any other questions?
No.
All right, thank you. This is what I'm going to tell you. I listened to all the evidence that's presented. And usually when you have family members to come testify, they always wonder, maybe I should have said this. Did I say something wrong? Did I not do this? But they didn't say anything wrong. They gave me great insight into you. I realized that your mom and your dad loves you, your aunt loves you, your first cousin loves you. And I know that sometimes people make bad decisions. Sometimes people make mistakes. There's a difference between bad decisions and making a mistake. So with you, I understand that you're young, but you're not appropriate for probation. You have the aggravated assault on January 24th, 2025, along with the choking on January 24th, 2025. And then you go back. And when you go back, you commit another felony. So you're standing before me, and I realize you're young, but you're standing before me having committed 3 felonies, and every last one of them are violent felonies. So there are consequences for that. So, and cause number 2020-25 CR 007063, to count 3, the court is finding you guilty. The court is going to sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2025 CR 00700, 2025 CR 007003. The state is taking in consideration 2025 CR 006031. There's an affirmative finding of family violence. There's to be no contact with the complainant, and the court will recommend the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but it's to help you with any drug, alcohol, or anger issues. And cause number 2025 CR 007003. The court is finding you guilty. The court will sentence you to 8 years in the prison. There's a $1,500 fine. The court will give you credit for any time served. This will run concurrent with 2025 CR 007000, 2025 CR 007063, taking consideration 2025 CR 006031. There's an affirmative finding of family violence. There's to be no contact with the complainant, therapeutic community, and there's an affirmative finding of deadly weapon. And cause number 2025 CR 007000. There's a $1,500 fine. I'm sorry, the court is finding you guilty. There's a $1,500 fine, 8 years in the prison, credit for any time served. This will run concurrent with 2025 CR 007003, 2025 CR 007063, taking consideration 2025 CR 006031. There's an affirmative finding of family violence. There's to be no contact with the complainant in the therapeutic community. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to your attorney. We can go off the record. Here's the thing. You're young. I know that prison is a rough place to be, but you're going to have to make some changes. You're going to have to figure out why you get angry, and you're going to have to solve that. Otherwise, what's going to end up happening is you're going to keep coming back and forth to somebody's jail and somebody's prison. And when you go to prison, do not become institutionalized. Go there. You can get your education for free. You can get a trade for free. You can do all of that for free. So make good use of your time. All right?
Yes, ma'am.
All right. Good luck to you.
Well, friends, that was almost a full bonus fourth hour there, 40 minutes, but worth it to see. There's so much we could say on this case. There's a lot of good points made out in the chat, and maybe we'll discuss it more in the future, but I do need to get on with my other things today. Tonight, 8 p.m. Eastern, 5 p.m. Pacific, join us for Sidebar. For those of you who are new out there, Sidebar is a show we do Tuesdays and Thursdays in the evening, and it's myself and four now other channel members who join me. We have a discussion. It's great fun, so be sure to join us for that tonight. Tomorrow morning we'll be back 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. If you're not a channel member, consider fixing that. It's a whopping $2.99 a month. We don't charge much, but you get access to the pre-show, early access to videos, all sorts of things. Speaking of early access to videos, currently out there for channel members and will be for everybody else later today, is an intriguing video from Judge Martin in Texas that involves a hearing on a photo lineup that it's kind of intriguing, and it's got an interesting conclusion, so you want to check that out. Back to tomorrow's morning show. Be sure to tune in for that. It's going to be a little different from what you've seen before, and we'll just leave it at that, and tune in if you want to find out how it'll be different. And Friday will be our 1-year anniversary for this channel, so be sure to join us for the live show then as well. Thank you all so much for joining. This is the whole reason why I get up early every day. You guys are great. I had a lot of fun today, and hope you did too. We'll see you tomorrow or hopefully tonight. In the meantime, go have yourselves a great Tuesday. Take care. God bless.